Civil application.
Yes.
On a hearing of 2023, well, there was a direction by law passed by the Honorable Chief Justice to hear out the appeal at an arbitrate. An order is there in a mandamus appeal filed by the respondent wife, claiming to be the owner of the property.
Very well. But is the
I will produce
order
the
of Chief Justice? Please just produce that order also.
Yes, I will
Mention with that order. Yes.
Tomorrow I shall mention.
Inclusion of a hearing matter.
Hearing told. Yes.
But the same place, the only difficulty is not my entire construction has been stalled. Suit for
we cannot.
but eviction under
with Millard, kindly leave Millard for inclusion of hearing matter, Millard.
No, we are not
2022 matter, Millard.
No, not right.
My lord,
I mentioned all electricity for hearing. That's not again.
Hearing, sir, please wait for some time. Wait for some time. Appeal we are not adding. Yes. It's an application or what? Is it an application? It will appear under the heading application. Yes.
Well, it is a hearing matter. Your lordship was kind enough to direct the matter will appear in the list of March matter. It's still not hearing matter.
Not right.
my lord, inclusion in the list, my lord.
What?
For AP application, my lord.
No.
Lordship, inclusion for application, your lordship, and also lordship, order 41 included, your lordship.
Yes.
And let order 41 rule 11.
Yes.
Lordship, application for lordship, may I application?
Yes.
May I be part of
And you have mentioned an application matter for any.
Yes.
My lord, on application civil, my lord, on order 41 rule 11.
Lord, pardon?
application matter?
Yes.
Application. So may I be permitted first application?
Also, hearing we are not adding. Yes.
Application for inclusion.
What is that? What is that? Yes. All right, no further mentioning today. We have exceeded sufficient matters. Come back on the next day.
Hearing of stay application.
No further mentioning today. One who is appearing. One who is appearing. Not today, Koda.
But item number 1, Shoini Chakraborty is appearing on appearance.
Since the relative of one of us, within bracket our full name, is appearing for one of the parties, let the matter stand released from our list with liberty to the parties to seek an assignment before the Honorable, the Acting Chief Justice, before a different bench. Next.
May I permit to mention my application?
No. No. As per the office report dated April 2, 2026, despite the direction of the court, the deficit court fees have not yet been put in by the appellant. Full stop, next para. Let the matter be listed under the heading Lozima for orders. Lozima for orders. It is Lozima for orders.
Item number 3, I appear for the respondent. Lord, matters appearing at my instance. This is your lordship's last order, 18th November. That was a direction upon the appellant to file paper books. 8 weeks from 18th November, that has not been done. I just wanted to bring this to your
The
lordship.
trial court records have not yet arrived. They could not have prepared the paper.
It's a fast appeal, man.
I'm given to understand the LCR has just arrived.
Your
So
lordship.
now, if your lordship directs, then they'll be able to.
That direction is already there whenever a notice is served.
If your lordship
directed, my lord, to put in the cost, we have deposited the cost to long.
Your friend's instruction is it has arrived. So if it has arrived, notice will be served. They'll file the paper. Lord Counsel for the respondents submits that despite a direction of the court, the appellants have not yet filed paper books. Full stop. However, from the office report dated July 9, 2020, it transpires that the office that the trial court records had not yet arrived till that date. Full stop. Since learned counsel for the respondent submits as per instruction that the records have since arrived, the office shall file a revised report and serve notice on the learned advocates for the appellants as well as the respondents for the appellants to prepare paper books as per previous direction.
Will it be your lordship's pleasure to indicate a time to file the paper books?
We have already passed our directions.
Unless the record comes, how can I file the paper book?
Very well. I'm grateful.
Next. Yes.
In terms of the observations of my lords,
Please,
my learned junior, and I have also, my lord, sent them the state a copy.
The list of dates filed by the appellants today be kept on record. Full stop. Hearing is concluded. The matter is reserved for judgment.
I'm grateful.
এটা জাস্টিস ভট্টাচার্যকে পাঠিয়ে দেবেন, এটা উনি জাজমেন্ট করবেন, তারপর আমার পাঠাবেন, মানে এটা ওনাকে পাঠাবেন। করো, ধরে ধরে করো, বেশি বেশি টাইম দিয়ে দেবে।
My lord, I'm for the appellant.
Yes.
I have the instruction to appear on behalf of the respondent wife. Lord,
My lord,
terms of
last
your law.
occasion, my lord had
Yes.
asked, had directed me for a substitute service, my lord. Paper publication has been done, my lord, but I was a bit late in filing the paper publication in the department on 8th July, my lord. After
They are there, their bank is now agreeable to, the bank seeks 45 days time to pay the amount.
No, my lord, this
That
is a
was their previous,
matrimonial. This is with regard to the matrimonial.
এটা কি দিচ্ছেন? ভুল ভাল দিচ্ছেন আপনি, নতুন করছেন নাকি কাজ? Why is it appearing as to be mentioned?
my lord, actually, on last occasion, my lord had directed for substituted service, my lord. I have done the paper
You are
publication.
appearing now.
I am appearing, my lord. Let a copy be served upon me, my lord.
Copy of what?
Copy of the applications, my lord.
Very well. Uh, uh, Since the respondent appears through counsel, comma, the appellant is directed to serve copies of the applications as well as a copy of the memorandum of the appeal on the learned advocate appearing for the respondent. Can 1 of 2025 be listed on July 20, 2026?
Deeply appreciate.
Great.
Lord, appear for the appellant, my lord.
How about the respondent?
Remembers, my lord, there was a request for us to, my lord, submit written instructions
In
from the
that
bank.
matter, the bank.
Yes, my lord. The bank.
Yes, they
sent, my
seek a
lord,
further 45 days time to put in there. So we'll keep it after a month. Today we are on 13th, so we are keeping on 10th August. Let us see.
Practically, one thing I would like to submit that interim order of injunction that has been granted by this honorable court is not practically affecting us. But the thing is that they have misrepresented the court to obtain this order.
What sort of misrepresentation?
My lord, they have stated that their EMI is being deducted. My lord, there is no document with regard to that aspect.
EMI being deducted by the bank for this loan.
Yes, my
my
lord.
lord, to take up page 95 of my application.
Let's come to page 95. Yes.
My, the first 2 months EMIs had been deducted. Kindly seize, my lord.
95.
Page 95. Seize, my lord. This is the
Can 1?
account statement. Yes, my lord.
আপনার কি মাথা ব্যথা খারাপ হয়ে গেছে নাকি? What nonsense. কি করছেন আপনি এটা? সবকটা ফাইল ভুল দিচ্ছেন? Mr. Bordhan.
My lord, seize the last 4 entries, my lord.
Yes, what do you say to this? Entries are there.
My lord, if the EMI has been deducted, has started to be deducted, then they are having the money. They
My lord,
could have
may I-
paid us and got the property
My
registered.
lord, may,
We
my lord,
don't
may I
have any
indicate
objection
what
to that.
exactly happens? May I indicate what exactly happens? my
Yes.
lord? Once we apply for a loan, my lord, the sanction is there. Then, my lord, once the sanction is there till disbursal, my lord, I am called upon to pay the EMIs. It is only
Mr. Bordhan, subject to payment of the EMIs, if you have not failed in the EMI, the bank can immediately.
no,
give
my lord,
the
they cannot because the mortgage is not being created. Because the mortgage has to.
money. How
My lord, kindly
it
bear
is
with me.
not how housing loan
My lord,
works.
I bow down. My lord, kindly bear with me.
Not
What
how.
hap- my lord, kindly, my lord.
You start paying the installments.
No, my
the
lord.
loan
What
is,
happens, my lord? I'll tell
that
you.
is why the
No, my lord.
installments are being deducted.
No, my lord. Once, my lord, until and unless an equitable mortgage is created, my lord, the bank cannot disburse the entire money. What the bank does is, my lord, my bank sanctions the loan. And I don't take the disbursement. I start paying the EMIs. My lord, kindly, my lord, that is the way, my lord. My lord, with respect, my lord. My lord, with respect, my lord. This is a my lord, loan for personal flat. This is not for my lord, a new flat. It's a resale flat, my lord. It's not being paid. My lord, kindly, my lord, with respect. With respect, my lord, then in that even, my lord, kindly looks at the EMI of.
It is special to Kotak Mahindra.
No, my lord, it's not special. I'll tell you what happens. My lord, we apply for a loan.
Mr. Bordhan, Do you mean to say that we have to wait till your entire
No. On the date when the registration is done, I get the IGR. The bank gets the IGR, gives them the check.
bank gives you then and there?
Yes.
So why are you asking for 45 days then?
No,
If
Malad, what?
tomorrow it is done, then
Malad,
tomorrow the
kindly,
bank.
kindly seize the email of the bank. Kindly seize it. What happens, Malad? Once this amount is not disbursed, the sanctioned amount is not disbursed, the loan gets cancelled. Kindly seize, Malad.
Has it been cancelled?
Yes. Kindly seize the email of
Then
the.
how can it be paid in 45 days?
Malad, the sanction for the last year has been cancelled. Malad, then Malad, I write to the bank. The bank replies me that please be advised that in view of the fact that the amount disbursed earlier could not be handed over within 60 days from such disbursement, hence the case stood cancelled. As per your request for resanction on 2nd July, tweeted a new request.
You
Please
give a copy of the email to them.
till the time an equitable mortgage is not being created, the bank cannot release the entire
Say
funds.
that the sanction has been cancelled due to the, because otherwise the system is that the bank immediately hands over the check.
Within 60 days, if I don't take disbursement, the sanction gets cancelled.
Yes. Say that.
That is not a disputed fact. The disputed fact.
No, let if they pay the amount, then the interest.
They don't have any problem if they, but by way of misrepresentation, they have obtained this order of.
No, why misrepresentation?
But
The EMI are being deducted, EMIs.
Well, if the EMI are being deducted, then it has to be presumed that the loan is ready for disbursal.
No. Because if the sanction period is over,
but the actions are
the
not.
counsel for the appellant submits comma by handing over the printout of an email between the bank and the appellant comma that due to non-execution stroke registration of the proposed sale transfer deed comma the sanction period for the housing loan obtained by the appellant has lapsed. Full stop. From the email comma it is clear that the bank is agreeable to resanction the loan but seeks further a further period of 45 days to disburse the amount in terms of the resanctioned loan. To next para, in such view of the matter, comma, it transpires prima facie that the appellants are taking sufficient steps to have their part of the agreement in question performed. Next para, be that as it may, comma, in order to enable the appellants to obtain the necessary funds from the bank, comma, the matter is adjourned till they will keep it on 24th August. On August 24, 2026, next para, comma, to next para, comma, for passing appropriate orders. Let us see if the bank does not then.
The interim order be extended till 31st of July.
The interim order is extended till August 31, 2026 or until further order, whichever is early.
And the receipt for service, the direction for filing the receipts.
The receipt of service filed to be kept on record.
I'm so grateful.
Thank you. Yes.
Item number 7.
From the office report dated July 10, 2026, comma, it transpires that special messenger costs have not been deposited by the appellants as per the direction of this court. Next para. The appellant is granted further time of a fortnight to put in such special messenger costs, comma, in default, comma, the matter be listed under the heading Lozima for final orders on July 29, 2026.
Item number 8 to 10.
Matter regarding to relay hawker eviction or last Thursday, Lordship passed an order to grant interim order.
Trivedi was not there, yes.
But
He's not there even today.
Mr. Trivedi is leading us, Your Lordship.
On his ground, we adjourn the matter.
Yes, Your Lordship.
But then what do you say?
It's all right.
When
This
can he
matter-
come?
We are paying for a short passover.
No question of short possible. We are hard pressed with time. We are extending for a limited period, keeping it tomorrow then? Tomorrow. And adjournment is, the interim order is till when? Let us see. Till 16th July.
The
Today
main
we are
matter will be taken up on 15 July.
13th, it will be very close. We are extending till the end of July, but until
Right.
further order. An adjournment is sought on behalf of the railway authorities. Let the matter stand adjourned for the day which of the interim order granted earlier is extended till July 31, 2026 or until further order, whichever is ordered.
Lordship, can it be on Friday, Lordship, tomorrow and day after tomorrow? Both the division bench matter has been fixed before the division bench, Lordship, and arguing on, sorry, Mr.
Tomorrow
Shami
we are
Mohammed.
keeping it in the list. Keep someone here to argue the matter. Yes.
Lord, this matter, my lord, I apologize once again. My lord, it is this matter, my lord, when the appellate court's decree was to be
Certified copy has not been.
certified copy, my lord, we have applied, my lord. It is old record, my lord. We are having
And counsel for the appellant submits that as yet the certified copy of the impugned degree has not been obtained. Push up next para, let the matter go out of the list for the present with liberty to the appellants to mention for enlistment as and when such certified copies are obtained and filed in the department.
so very grateful.
File it in the department
Yes,
and then mention. Have the entry number and then mention.
Item number 12.
You are appearing?
Yes,
Yes, Mr. Bhattacharya, what is that?
Here, my lord, defendants are the appellants before your lordship.
Is there any section 5? No.
Section five allowed.
Achha.
And
What is
hearing was there and in presence of the
Right.
section five was allowed.
What is the matter?
My lord, defendant is the appellant before your lordship. Suit for declaration of title injunction declaring that the coin constitutional part is the print of the absolute monarch. However, my lord, suit was dismissed on the ground that defendant number 1 who filed the legal statement, no substitution or settlement application was filed. Even, my lord, the suit was abandoned as a whole. Here, plaintiff admits that they want
So
job.
trial court dismissed the suit,
Yes, ma'am.
held that it had abated.
Yes, well, your lordship has issued the issue
So
number
then appeal court reversed it.
reversed it and declared that the Logman Ali used the diet. He has no any right to transfer the, though he was made party. Your lordship can see the plain, my lord.
Plaint, where is it annexed? Plaint,
Plain and WS, they are
where do we find it? Plaint and WS?
there is no whisper in the state that the Logman Ali has no any right. Even in the, my lord,
No, what is the plaint case? That Lukman Ali,
Logman Ali is the owner of the support. It is admitted by the plaintiff.
right?
Thereafter, he stayed. Then one Haji Eli box is the owner, and after exchange the property, Paramananda and one Jagannath are the owners. Your lordship can issue number 3 and 1 of the trial court. Thereafter, your lordship can issue the appellate court judgment. Page, my lord, decision with reasons. Start.
Could we see the trial court first?
Yes, my your lordship can sign court. Trial court elaborately decided the case. Only issue number 3, whether the plaintiff have right title.
Page of the trial court, Mr. Bhattacharya.
Trial court judgment, my lord. Page, my lord, your lordship can see the
So, yeah, page 5.
page 7.
Issues?
Issue number 3,
Achha, very good.
page 7, my lord.
Page 7, yes, issue number 3, right.
Lordship got it, my lord?
Got it.
Issue number 3. The Laniadu for the defendant at time of argument submitted that DW1 is cross-examined as a state that Paramananda executed power of attorney in favor of Horiar. The suit body was sold out after the death of Paramananda Pandey. Plaintiff could not prove his position in the suit property, so the plaintiff are not entitled to the relief as well. Running of the plaintiff at the time of argument submitted from the exhibit 4, it is clear that one power of attorney was executed. Exhibit 4 is a registered document, so the presumption shall be that the document is genuine. The plaintiffs are in possession of the suit property since 1956. The record of right of the suit property are also in the name of the plaintiff. The plaintiffs are paying tax on the suit property, so the government has recognized the plaintiff as its tenant. PW1 corroborated the plaintiff case in affidavit in chief and in his cross-examination stated the arrest record of rights of the suit property was recorded in the name of Paramananda Pandey and Maya Devi. The suit property originally belonged to Haji Eli Box. Paramananda Pandey bought the suit property from Haji Eli Box by an exchange deed. The PW could not tell as to how many children did have the said Paramananda Pandey. The PW1 further said that the purchased the suit property after the death of Paramananda Pandey. He also said that he purchased the half of suit property from the legal heirs of Sudarshan and Saraju, and other half from Kashi Prasad and Sitaram. The cross-examination of PW1 has differed by the, I have already handed over the PW1 was differed by the defendant, but he could not complete the cross-examination of the PW1 at the time of argument. The learned advocate for the defendant submit that there is no need of further cross-examination of PW1. The DW1 corroborated that Stevens case in his affidavit in chief, and in his cross-examination he stated that he purchased the suit property from Logman Ali, the defendant number 1. Logman Ali purchased the suit property from Anil Jagannath and Paramananda, who are the owners. Sucheta Pandey, Meena Kumari and Lakshmi Kumari. Logman Ali got the suit property by registered power of attorney from Anil Jagannath, Sucheta, Meena Kumari and Lakshmi Kumari on 1/1/96. The Deoluan said that he was not present at the time of registration of the power of attorney. He had filed the said power of attorney in the present suit. He further said that no one from Anil Jagannath, Sucheta Pandey, Meena Kumari and Lakshmi Kumari shall depose in the present suit. That he said that he did not file the power of attorney dated 1/1/96 in the present suit. He also said that he has no document to show that the power of attorney dated 1/1/96 was executed. He could not remember the number of his purchased each. He said that the suit property is cultivated by a labor. In the suit plot number 92, very important, 92, there is a pond, it is pisciculture research. In the suit pond, they threw মাছের চারা. He could not tell from whom he used to purchase মাছের চারা from which market. He said that no one from the market or any fisherman or the labor shall depose in the suit. The suit property sold in 1956 in Pakistan. He did not know whether the suit property was purchased by the plaintiff from Sudarshan, Saraju, Sitaram and Kashi Prasad, Jagannath and Paramananda Pandey executed power of attorney to sell the suit property in favor of HON'BLE process. In this now, my lord, the DW2 in his affidavit chief said that he knows the plaintiff, the defendant and the suit land and corroborates the defendant case. In his cross-examination, he stated that he has land near the suit property. The suit plot numbers are adjacent to each other in one place. He saw the Xerox copy of the sale deed in the year 1952 executed by Eli Box in favor of Paramanand Pandey. He also saw the Xerox copy of the registered power of attorney in favor of Logman Ali in 1956. He did not know whether the suit property was sold by Jagannath and Paramananda in favor of Sudarshan, Saroj Sitaram and Kali Prasad on 10th August 1956. From the material available on the record and the evidence submitted by both the parties, it appeared that plaintiff and the defendant both admitted, or even in his cross-examination also, plaintiff and defendant admitted that Paramananda Pandey and Jagannath Pandey were the original owners of the co-scheduled
Everything is held by the trial court, but it apparently the 2004 deed only a photocopy was produced.
Yes, ma'am.
Xerox copy, not the original.
No.
So in his evidence, did he explain as to how why Xerox copy?
Well, he said that this is destroyed or thing.
Then sufficient proof was given. Sufficient explanation was given. Secondary evidence could be taken.
But my lord, your lordship has the issue number what? Page 11, my lord. Page 11 of the trial court.
Yes, issue number 1.
Issue number 1, 11, last 11 page.
1 is dead.
One is dead. Then
according to them, defendants, you don't have any title in the property. You are just disturbing.
But my lord, in this case, my lord, record of rights are done in favor of the defendants, and they are cultivating and they are doing the pisciculture. Now, my lord, record of rights, my lord, does not create any title, but my lord, the evidence of possession, there is no dispute. Your lordship, there are.
But the court holds, for this reason, it cannot be said that the suit is not maintainable. Trial court's finding is also it is maintainable. It cannot be, trial court's finding, page 12 is clear. That it means that plaintiff had knowledge that defendant number 1 is dead, did not add legal heirs, suit is already abated against deceased defendant number 1. Therefore, judgment of decree cannot be executed against the legal representative of defendant number 1. But for this reason, it cannot be said that the suit is not maintainable. So it is maintainable against the rest. So what is your ground in the second appeal? That it is abated as a whole.
No, my lord.
What is your ground in the second appeal? That it is abated as a whole, the suit.
No, no.
What is your ground? Tell us your ground. Second appeal. What is the substantial question of law?
Four.
What is the substantial question of law, Mr. Bhattacharya? You have seen the facts. If that is the substantial question of law, we are dismissing it.
My lord. Four.
What for?
Four.
Formulate it. What is the substantial question of law?
My lord, lower appellate court below, Adin law, by not holding that the appellates produce all documentary evidence of ownership, the school lands in question, also by producing the registered title deed and prove possession of the said land by producing the record of rights in their names of computerized records.
You did not produce any title deed. Did you? We don't find any title deed being exhibited by you. Your exhibit list is there at page 6 of the trial court.
Yes, ma'am.
Original sale deed number such and such date 2004. That is of August 2004, subsequent to the plaintiff's sale deed. You see the date, page 6 of the trial court, Mr. Bhattacharya?
Even a police the given by the even my lord, the Nukul Mundal's evidence as well as Nitai Mundal evidence is very relevant, my lord. It's very vital.
That is not a substantial question of law.
My lord, here question of law, my lord, your lordship, the EBT is my lord. Four, my lord.
Have you taken this ground before the trial, first appellate court?
4-7.
Where is the discussion before the first appellate court? This ground?
First appellate court, my lord, only says.
To take this ground, it is not argued even before the first appellate court. How can you take it for the first time here?
First, my lord, appellate court, you also can see the appellate court decision is, my lord, confuse the, my lord, contradictory of the ownership. One says that Jagannath and Paramananda are the owners of the land.
Jagannath and Paramananda executed sale deed in favor of the plaintiffs.
No.
Paramananda did. Part of it.
Paramananda did.
Then?
And not Jagannath. But we are the my lord from the Logwan Ali, my lord. He actually exchanged the deed of from Logwan Ali to Eli Box.
Both the courts have held that it's found from the records that Paramananda and Jagannath purchased from Lokman. Lokman did not have any title. Did you purchase from Lokman?
No. Logwan Ali is
You purchased from whom?
Power of attorney holder, and my lord, thereafter, my lord, power of attorney holder.
Who was the owner? Power of attorney holder does not have title.
Actually, my lord, Paramananda, Jagannath and Paramananda. Jagannath and Paramananda.
You purchased from whom?
Paramananda legal heirs and representative.
That is after August 2004.
After Paramananda died.
Not only that, after their plaintiff sale deed. Plaintiff sale deed 19th March 2004. Yours is 26th August 2004.
And you lordship,
that argument is not there before either.
Even my lord, you lordship can see in the plain prayer.
No, forget the plaint prayer. Plaint is passed. What are the issues? That is not an issue even in this suit. Whether the defendants have right title interest in the property is not an issue in the suit.
Plaintiffs.
You are saying that defendants' title deeds were there also. Defendants also produced title deeds.
Here, my lord, plaintiffs only discuss by the trial court. Plaintiffs, whether the plaintiffs have right title interest and possession of the suit body.
Yes.
After, my lord, adducing the evidence and other cross-examination says, no plaintiff has any right title interest and possession. Because plaintiff have admitted that Paramananda Jagannath are the original land of the constitutional property, and also admitted in his cross-examination, suit property originally belonged to Haji Eli Box.
Originally, maybe, or Paramananda, both sides say that Paramananda and Jagannath purchased the property. You purchased from whom?
Paramananda legal heirs. My lord, defense case, my lord. Paramananda and Jagannath Pandey were the absolute owners. Given one is, my lord, vital. One stated that suit property belonged to one Haji Eli Box. He exchanged the suit property with Paramananda Pandey. Suit property was correctly recorded in the name of Paramananda. Paramananda died, 2 daughters. My lord, one Maya died, living with one Ishwar Chandra, and the said defendant number 1, Logman, is the son of Logman transferred the suit property in the favor of Nokul Dhiren and
Who are these Sudarshan, Soroju, Kashi Prasad and Sitaram?
Sudarshan Sarju Kasukar. They are the sons and heirs of the Paramananda.
But it's recorded that they purchased from Paramananda. Sons purchased from father.
After the death of Paramananda, his legal heirs are. And
No, page 910 of trial court. Plaintiff produced certified copy of sale deed from which it appears that Sudarshan, Soroju, Kashi Prasad and Sitaram purchased suit property from Jagannath and Paramananda, not Pandey. They also produced a sale deed of 2005 from which it appears that plaintiffs purchased some portion of the property in Khaw.
But when your lordship said that total case of the plaintiffs and dependent, there is some dispute regarding the transfer of the suit property.
What dispute? No dispute.
And my lord, title is not clear of the plaintiffs. Your lordship,
Very clear. They produced title deeds.
My lord, plaintiffs, my lord, your lordship of the prayer, there is no whisper in the plaint, my lord, or prayer that the deed which was purchased by the defendants or any other, there is some dispute.
Your deed is not an issue in either of the courts below. Even before trial court, you did not set up that case.
But my lord,
In the trial court, it has been recorded defendant numbers 2 and 3 filed their written statement. You said the tailor has been prepared in your names and you have purchased the suit property by registered sale deed, which is subsequent to this their sale deed.
Record of right does not create any.
No, that all of us know, yes.
Your lordship, on the basis of that question of law, your lordship can, because we are in possession, and my lord, we have been possessing.
Record of right does not create title, then we'll admit on that question of law. Whether that created title.
No, my lord, regarding evidence of possession is there.
That does not confer title on you.
Number one, my number two, my lord, your lordship can see the paragraph, my lord, trial court judgment regarding the abatement. I cannot say that. But my lord, in the appellate case or appellate order, there is no whisper whether any defendant Logmanari died or not. There is no whisper, my lord. Even your lordship can see the decision of lower appellate court decision, my lord. Decision with reason. There is no reason. There is very whether defendant number one died, whether they have taking any steps or not. There is no any, my lord, ground or any whisper, my lord. Last question, my lord, suit. There, my lord, specifically stated the PW1 admitted in his cross-examination that the defendant number one, Logmanari, died in the month of March 2013. He shall not make the legal heirs of defendant number one as party in the suit. It means the plaintiff had knowledge that the defendant number one is dead, but the plaintiff did not add the legal heirs of the defendant number one. Even in this judgment, my lord,
no, Mr. Bhattacharya. The present appeal has been preferred against the judgment of reversal. First of next para, the trial court considered the point now raised by the defendants to appellants as to the suit having abated on the demise of defendant number one, Lokman, and came to the conclusion that at best, the judgment and degree of the suit cannot be executed against the heirs of the deceased, but for that reason, it cannot be said that the suit was not maintainable. Next para. However, the learned trial judge went on to hold that the plaintiffs could not prove their title in the suit property. Next para. The first appellate court, on the other hand, considered the documents. It is the finding of both the courts that the property originally belonged to Paramananda and Jagannath. The appellate court proceeded on the basis of Exhibit 4, a sale deed dated August 10, 1956, whereby Paramananda and Jagannath sold the whole property to Sudarshan, Soroju, Sitaram and Kashi Prasad, the legal heirs of whom, in turn, sold the whole property to the plaintiffs, vide deed number 567 dated March 19, 2004, within bracket exhibit 5, bracket close, full stop, next para. Although the certified copy of the deed dated March 19, 2004 was produced by the plaintiffs, comma, sufficient explanation for furnishing secondary evidence was given in the evidence of the plaintiff's witnesses. Full stop. Next para, the learned first appellate judge disbelieved the case of the defendants that Lokman Ali, comma, in the capacity of either power of attorney holder of the owners or in his own capacity, comma, could have transferred the property to the defendants. Full stop. Next para, upon a perusal of the judgments of both the courts, comma, we find that the matter involves pure questions of fact. Full stop. Next para, thus, comma, we do not find any question of law, comma, let alone any substantial question of law, comma, being involved in the appeal. Full stop. Accordingly, SAT 25 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, comma, Can 2 of 2026 is also dismissed without any order as to costs. Next.
My lord, kindly pardon me, item number 2, I was coming and the matter is called on. Whatever.
Yes.
I'm appearing for the appellant,
For the respondent.
My lord, may I only pray for a 1 minute pass over, my lord? I'm just about to reach your lordship's court from the other building. Just 1 minute, my lord, if it's possible.
You are for the respondent.
Or, my lord, it's my appeal. It's my appeal, my lord.
My appeal, my lord.
He's not leaving. This is item number 13. Trust tested Khimji Keshavji. You are appearing. Someone else is
item
appearing.
Number 14. Item number 14.
We are taking up 13. Yes, please move.
The judgment of
Oh,
effort.
I'm
Landlord
use the
suit.
mic.
Yes.
Mic. Yeah.
Landlord suit for eviction dismissed by the
which act?
97 Act. Dismissed on the ground of the suit was on the ground of default and reasonable requirement primarily.
Decreed on what ground? Reasonable requirement.
No, dismissed.
Oh,
Dismissed.
suit, you are the landlord.
Yes.
Both courts dismissed.
Both courts
on what ground?
But so far as default is concerned, court found that there was no default. I'll take your lordship to the details.
They complied with 7.2.
My lord, in my respectful submission, they did not, because the court directed the amount adjudicated by the court to be deposited in court, but the act requires to be deposited with the landlord.
Did you raise this question
Yes.
to the court?
Yes.
How? In arguments?
Yes. As well as, my lord, obviously in the
97
arguments.
What about reasonable requirement?
That is not the only ground. I have other grounds also so far as default is concerned. And, my lord, reasonable requirement, my lord, Section 6(1)(d) requires the landlord to, my lord, disclose any suitable accommodation.
Yes.
But my plain case is that I do not have a suitable accommodation. I may be a owner of 1 building, 2 building, 10 buildings. But
what is the alternative accommodation you have?
I don't have. I am a trust. I am functioning from a table space as a licensee
The
under.
court came to the finding that you have
That is the interesting question. Lord. The court did not decide on that issue. The court simply went on the premise that I have concealed the fact that I am an owner of another building without even coming into a finding that whether I am in possession of a single room in that building or not.
It was your owners to prove because your ownership of that building was produced by somebody.
In my cross-examination, it came out for the first time.
It was your duty to
I am
inspection and
I
show.
am the owner. I may be owner of 10 buildings,
No,
but I have. Well, so far as 6(1),
if you admit that you are the owner of a property, it's your burden to show that there is no alternative accommodation there. So what did you do to that end?
In my respectful submission, my lord, the courts have held that once the landlord has raised an issue of reasonable requirement and he has claimed that he has no suitable accommodation, primarily the court will presume in favor of the landlord, subject to be rebutted by evidence by the defendant, by the tenant. But Lordship knows Balbir Singh, my lord, thereafter Balbir Singh has been followed in many cases, where, my lord, primarily it is presumed in favor of the landlord. And here also, my lord, I have, my plain case goes on the basis that I do not have a suitable accommodation.
So they
I
had
have,
deposited with whom? With the court.
my lord, Lordship.
The 7-2 deposit was made with the court.
Yes, according to the, I don't know, because I have not seen, my lord, whether it was deposited or I did not get.
What is
According
the
to
court's finding? It was deposited in
yes,
court.
After that, after 7-2 order, my lord, I don't find any recording as such. And my lord, I have other grounds so far as default is concerned. But substantial question of law.
What question?
7-1 and 7-2 are independent provisions. But simultaneous applications before the same court in the same suit are not maintainable.
Caption is immaterial.
But the provisions, even, my lord, single bench judgment is there, my lord, Lordship
Maybe.
knows Kali Thodi.
7-2 subsumes 7-1.
Yes.
If you file a 7-2, then that will be decided. Here
Yes.
that was decided.
But what I'm trying to establish before Lordship is, suppose, my lord, a situation arises where 7-1 is allowed and the tenant complies with 7-1. 7-2 also allowed. Tenant does not comply with it.
7-2, 7-1 compliance is virtual. No, 7-2 has to be compliant.
If he does not comply and he complies 7-1 and goes on depositing the current
Here,
rent.
no, here he did not comply with 7-2.
In my respectful submission, no, because I did not get any money. According to the act, the landlord should get it.
Let us come to section 7.
Yes. Seven two, my lord.
Both are there. Pay to landlord or deposit.
That is 7-1 subject to
Yes,
correction.
yes.
7-1 is or.
Yes.
7-2 is if any suit referred to in subsection 1, there is any dispute as to the amount of rent
7-2
payable.
is only with the civil judge.
Yes.
Even more against you.
No, my lord. Kindly cease. The last part, after the adjudication part, and thereupon the tenant shall within 1 month of the date of such order pay to the landlord the amount so specified in the order.
Do you have a copy of the 7-2 order?
Yes, my lord.
Were they directed to deposit with the court?
Yes.
In the 7-2 order, they were directed to deposit with the court.
I have filed a can, my lord. There, the order is there.
No, they complied with the order. If you did not take a demur at that point of time, Mr. Shen, how can you take it now?
My lord, in my
And that too
respectful
in the second
submission, my lord, it is for the tenant to challenge that order, if at all, because it is against the statute. The statute
They were
gives him
aggrieved.
the
They were
protection.
not aggrieved. They made an application. They were directed to deposit.
Yes,
They directed.
but the default is there under the act, my lord. If the court passes an erroneous order which I follow,
Did
which
you
is
take this point before at the hearing of the suit?
yes,
At the hearing of the suit, you
Yes.
took it. And regarding reasonably, you don't understand your point. If you admitted that you are the owner of another property, it's your owners to show
my
whether
lord,
you have accommodation.
may I, my
You
lord,
did
take
not
your
show
lordship?
your accommodation.
May I show your lordship the previous provision, 1956 Act, which was section 13(1)FF. My lord, what was the language? May I place?
Let us proceed on the basis of the current statute. Why going
Because,
to
my
the-
lord, I want to distinguish why the legislature changed its.
Let us see the current language first.
Very well, very well. Section 6(1)D, my lord, where the landlord or any person for whose benefit the premises is held reasonably requires the premises for his own occupation, and the landlord or such person is not in possession of any suitable accommodation within same municipal corporation or municipality, or in case.
Yes. Now, what is the difference with the previous statute? You
But
wanted to
here, your lordship will kindly see, is such person is not in possession of any suitable accommodation. And, my lord, the previous provision was subject to the provisions of subsection 3 capital A, where the premises are reasonably required by the landlord for his own occupation, if he is owner or for the occupation of any person for whose benefit the premises are held, and the landlord or such person is not in possession of any reasonably suitable accommodation. But the legislature has consciously done away with this word reasonably. But the test of reasonableness, in my humble submission, my lord, is tested by the court. That is done away with in the new act. The suitability of my accommodation, I know where my shoe pinches. And I do not have any other suitable accommodation in any other building.
Rather, Mr. Shen, it has been made more rigorous for the landlord in the sense that if it was previously reasonably suitable, it would suffice. Reasonably suitable. Now it has to be suitable.
And the suitability
qualification of reasonable.
Yes, and the suitability is for me to show. Yes,
you did not.
But in the cross-examination, they brought out from me that I am owner of another building. In my cross-examination and in his evidence, it is palpably clear that several suits for evictions are pending before the same building and the other building.
How does it help you?
Fully tenanted. Both buildings fully tenanted.
You had to show in this particular suit something. Had to have a local inspection or rent receipts of the other tenants to show that it is tenanted. That would suffice.
But
you did not take any effort.
In my cross-examination, no question was put regarding possession.
Why should they? They should stop. That is the art of cross-examination, Mr. Shen. Once you admit you are the owner of a property, another property, it's your onus to show that it's not suitable for you.
There was not even a suggestion.
Why should they? That would suffice for them to show that you have an alternative accommodation. It was for you to call yourself on recall or at least to prove something. You know that.
May I take your lordship, in the trial court's judgment?
Absolutely.
In the trial court's judgment, they have relied on a particular judgment of the Honorable Supreme Court, where there was no local inspection.
No, there are certain cases where no local inspection may help you. If from the evidence it's proved. What is the other evidence you produced? If you produced a rent receipt of the other tenants, that would suffice. You did not take any effort to that end. Let us see the finding of the how it was dealt with the rent default.
Very well.
Default.
The issue number 4 is rent.
The appeal court and trial court are similar in ratio.
Yes.
So let us see the appeal court. Let us go from there, or whichever way you want us to. Should we look into the trial court first?
Trial court first,
Which page?
Page 10, issue number 4.
Yes.
Whether the defendant is a defaulter in payment of rent or any component of rent. The tenancy agreement provides that rent is prima facie ad hoc, including all components. But if in the meantime there is any increase or any component is added by
7-2, it has been adjudicated, so that challenge stands unchallenged.
No.
So your ground is that it was not
a civil revision was filed by the plaintiff, Supreme Court, but even then the court holds that is an interlocutory order, interlocutory stage, issue framed.
No, 7-2, the amount was determined by the court. That remains. Up to Supreme Court, it was not set aside.
No.
So your issue is different. Your issue is that it was directed to be deposited to the court.
That is one issue.
What is the other issue?
Other issue is, my lord, regarding the component of rent. That is why I am indicating to your lordship the terms of the tenancy agreement, which, my lord, postulates that rent ad hoc includes other components. But if in the course of time, other components are added or property taxes increased, like in this case.
7-2 preferred revision went up to the Supreme Court. How can you reopen that?
Issue frame, that is it's trial. It is subject to trial. And they've gone into it. The courts
Framing
have
of
gone
issue
into
does not mean that the court can reopen it.
But the courts have.
If it has done it wrongly, but the conclusion is correct.
But so far as the other
decide the issue which has been settled by the
those issues were not before the Supreme Court or before this Honorable Court.
Constructive res judicata then. You challenged that order was challenged by you in a revision. Went up to the Honorable Apex Court. It was affirmed up to the Apex Court.
The Lordship knows that is in the interlocutory stage.
No, 7-2 adjudication, as far as 7-2 adjudication is concerned, that is final for the purpose of determination of the rent. It's an interlocutory order in that sense in the appeal, in the suit, in the sense that it's not the final degree.
Yes.
In that sense, it's interlocutory, but the adjudication is not tentative. It's an interlocutory order passed in a suit, Mr. Shen, but it's conclusive for the purpose of determination of the rent. That is the whole scope of 7-2.
My point is, issue has been framed.
You confuse some other court on that.
But may I take your lordship? May I try my luck?
To confuse. Landlord question show us that is more important. 7.2 we won't reopen even if the court did.
But here the court admits that this appeal court, that commercial surcharge is payable in addition if it is levied, then says it includes, rent includes and is paid.
Shane, neither the trial court nor the appellate court could reopen that issue after it has been finally decided, conclusively decided. As far as determination of rent is concerned, 7.2 is conclusive. That is the entire scope of 7.2. That is why we are saying it.
But
the court has to see whether default has been in the suit. The court can try out whether default has been committed subsequently. But if they deposited the rent as per the direction of the court, how can you say they defaulted?
Prima facie, it is dehorse the act.
Because it was given to the...
Not to me.
But
violates the statutory provision.
If you challenge the 7.2 order, if the 7.2 order directed them to deposit with the court and not the landlord, then that question is also covered by constructive res judicata there. That it has been affirmed along with that. Difficulty lies there, Mr. Shen.
Well, all points of law subject to correction are kept open for trial. My humble understanding.
Any other point?
But the court has not gone into...
So if you have understood, up to now 3 points primarily. One is that regarding alternative accommodation, yes, you admitted in your cross-examination that you have an alternative accommodation.
No, I am an owner of another building.
You are the owner of another premises within the same municipality. But you say alternative accommodation presumption should be in the landlord's favor. That was never rebutted by them. That is your case.
Yes.
So one, regarding this default in payment of rent, first is that all the components of the rent of rent were not considered by the appellate court, and that's why it's a legal error.
Misconstrued,
legal error. Third is that as per the statute, it is to be deposited with the landlord after 7.2 adjudication, but it was directed to be deposited by the court, and they went on depositing with the court. These are the 3 points up to now.
Well, the court, in my humble submission, again section 7, to make a finding regarding section 21-22, because rent controller payment is being made by the tenant.
Yes.
So whether the rent control payment is being made in accordance with the act, whether the section 21 application...
Pure 7.2, Mr. Shen. That is attained finality. How can you reopen 7.2 now?
But because if there is a violation of the statute, if there is no affidavit, for example, in the application, if there is any false statement, the court has to come to a finding, my lords, that there has not been a false statement made by the tenant in section 20. Section 21 application was not even considered by the courts below at all.
While deciding 7.2?
Yes. Or even finally.
Finally, not.
The issue framed, discussed, threadbare.
What is the issue? Let us see.
Page 10, my lord. Whether the defendant is a defaulter in payment of rent or any component of rent. Issue number 4.
7.2 decided what is the total rent?
Yes.
Including component with or without component.
Yes, it did.
So that on that premise, it was not reopened in the issue. The quantum of rent was not reopened in the issue.
No.
How can you say that?
Well, kindly see.
That has been deposited by them. How? Let us see how this question was dealt with. Not deposited with the landlord. Let us see how that was dealt with.
All questions were not really dealt with. That is the difficulty.
If you raised it, it must have been dealt with. Let us see where you raised it. You say you raised it.
Yes. In my written objection, it is there.
Written objection to what?
7.2.
Forget 7.2 chapter. 7.2 is much long over when the suit is decided. In the hearing of the suit, you said that you had raised this issue. We asked you specifically, Mr. Shah.
Yes.
What is that dealt with?
My lord, if your lordship kindly takes page 11, after the continuing sentence from page 10, he tried to draw the attention of this court that
Yes,
admittedly
yes.
the defendant did not deposit the admitted arrears of rent as per subsection 1 of section 7,
That's a
and for
different
this
point.
reason the
That's a different
defendant
point. 7.1 says with the court.
he further added that the finding of the court in connection with application under 7.1 and 7.2 is a tentative final. Very well, that is tentative.
Sorry, Mr. Shen, you did not raise that.
Kindly gives me a minute.
So the next paragraph starts with having regard to the argument.
But in my affidavit evidence, my lord,
it is a question of law.
my lord, at page 167 of my application, it is a part of my affidavit in evidence. That's subparagraph E.
Mr. Shen, forget your evidence.
I raised this issue. Your
In
lordship,
evidence, you have raised this issue. Please, come on. There's a limit to everything.
the plain case I cannot
Your
make
evidence
out.
is not an argument in the suit at all. Your evidence, whatever you stated in your evidence, that's a question of fact. That has factual value. That was dealt with by the court. You did not raise this question. 7.2 was, it was a specific issue in the suit before.
This is my
Acha,
examination.
let us see the 7.2 order once.
7.2 order your lordship will get.
And the revisional court's order.
Page 147 of my application. Application under section 7.2 filed by the defendant taken up for hearing. Today it was fixed for examination of DW in the matter of 7.2, but learned advocate such and such rate 2156. And further, they are admitting the claim of the plaintiff that rent is due for 3 months from August. There also I will address your lordship, my lord. The learned advocate on behalf of plaintiff submits that since the defendant has adduced evidence and the plaintiff is not permitted to cross-examination the defendant, the plaintiff will be prejudiced. In my considered view, it is not mandatory to take evidence to depose of an application 7.2, and furthermore, since the defendant accepted the claim of the plaintiff, I don't find there is no point in continuing examination. Plaintiff has claimed, so I was debarred from cross-examining. Plaintiff has claimed that without evidence not be possible for the court to determine rent. And thereafter discussion. The second part of the next page, my lord. On perusal of clauses 5, A, B, C, and D, I find that nowhere plaintiff has mentioned about amount payable by the defendant. Plaintiff stated 5D of the defendant is also a defaulter in payment of commercial surcharge or property tax tenanted portion, but the plaintiff did not claim what amount of commercial surcharge are to be paid by the defendant. That is the statutory duty of the tenant to find out and pay. 5.8. In absence of any specific claim by the plaintiff, defendant is not bound to pay any amount. That apart, I fully subscribe to the view of learned advocate and the defendant that since plaintiff has filed the suit by paying court fee on the calculation of rent to if 21 cannot claim more than 2156. On thorough reading of paragraph 2 of the plaint, I find that plaintiff specifically pleaded monthly rent such and such, and the amount.
No, sorry, Mr. Shen, we are not.
Well, kindly see at the last.
Yes, you have seen.
He has further directed to deposit an amount equivalent to monthly rent in court in favor of the plaintiff.
The present challenge has been preferred by the landlord stroke plaintiff stroke plaintiff in a suit for eviction, primarily on the ground of default in payment of rent and reasonable requirement under the provisions of Section 6 of the West Bengal Premises Tenancy Act 1997. By the impugned judgments and decrees, both the courts dismissed the suit. Next para, learned counsel appearing for the appellant submits that both the courts below substantially erred in law in refusing to grant decree on the ground of reasonable requirement, comma, merely on the premise of a purported admission of the plaintiff's witness in cross-examination to the effect that the plaintiffs own another property within the same municipal limits as the suit property. Mr. Learned Counsel argues that as per the settled legal position, comma, the initial uh, presumption is that of the landlord not having any suitable accommodation, which then has to be rebutted by the defendants. Because in the present case, comma, there being no such rebuttal evidence, comma, it is argued that the learned courts ought to have granted the decree of eviction on the ground of reasonable requirement. So next para, it is secondly argued that the that as per the agreement, tenancy agreement, comma, the rent fixed was merely on an ad hoc basis, with other commercial charges being included in the components of the total amount payable for occupation of the tenanted premises. First up, it is argued that neither of the courts below took into account such component of the rent and went on to decide erroneously that there was no default on the part of the defendant tenant in payment of rent. First up, next para, it is contended by the appellants that such question gives rise to perversity, comma, being contrary to the agreement between the parties and the evidence of record on record, and as such ought to afford a ground for admission of the appeal. For some next para, thirdly, comma, learned counsel places reliance on subsection 2 of section 7 of the 1997 Act, which mandates that upon adjudication under the said provision of the quantum of rent payable, comma, the rent then has to be paid to the landlord and not deposited in court. Full stop. Contrary thereto, comma, the learned trial judge directed deposit in court, comma, which was then complied with by the defendant's respondents. Full stop. Next para, learned counsel, comma, in his usual fairness, comma, submits that a revisional application was preferred against the said order, which was dismissed, against which an SLP also failed. Full stop. However, comma, it is argued that by framing issues on the question of default, comma, the trial court reopened the said issue. Full stop. It is submitted that the adjudication under section 7 within bracket 2 was merely tentative in nature, comma, subject to the final adjudication of the suit. Full stop. As such, comma, the courts below ought to have taken into account this component of the matter. Full stop. It is further argued by learned counsel that the said question gives rise to a pure question of law and, comma, as such, comma, can be raised at any point of time, comma, even for the first time in the second appeal. So the next para, however, comma, we are unable to accept the contentions of the appellant. For the next para, insofar as the reasonable requirement ground is concerned, comma, section 6 within bracket 1 within bracket small d of the 1997 Act stipulates that where the landlord or any person, comma, for whose benefit the premises is held, comma, reasonably requires the premises for his own occupation and and the landlord or such person is not in possession of any suitable accommodation within the same municipal corporation or municipality, MC capital, M capital, or in any other area within 10 kilometers from such premises where the act extends, italics shesh, comma, the same affords a ground of eviction. For sub next para, although the appellants seek to argue that in view of the deletion of the expression double inverted reasonably double inverted clause from the predecessor statute, that is the 1956 Act, to qualify the term double inverted suitable double inverted clause, comma, the same, comma, in our opinion, comma, does not mitigate the rigor on the landlord to prove the suitability or the unsuitability of such alternative accommodation nonetheless. Full stop. Next para. Since the lack of suitable alternative accommodation is an inbuilt sine qua non of getting a decree on the ground of reasonable requirement, comma, once the landlord admits in evidence that the landlord is is the owner of another premises, comma, it is for the landlord to show, comma, either by local inspection or by other evidence that the landlord does not have any suitable accommodation there. Full stop. On the failure of the plaintiff stroke appellants in the present case to do so, comma, we do not find any legal error in both the courts below, dismissing the suit on the ground of reasonable requirement. For sub next para, insofar as the quantum of rent is concerned, comma, upon a determination under section 7 within bracket 2 of the 1997 Act, comma, the same becomes conclusive insofar as the quantum is concerned. Full stop. Contrary to the arguments of the appellants, comma, the quantum of the rent, comma, after determination under section 7 within bracket 2 of the 1997 Act, comma, does not remain a tentative issue but attains finality. Full stop. Next para. The issue framed by the trial court was not on the quantum of rent, but as to whether the defendants were defaulters in payment of rent and all its components. First of, once having been decided under section 7 within bracket 2 as to what is the total quantum of rent within bracket with or without its components, bracket closed, comma, the said question could not have been reopened by the trial court even at the final hearing stage. First of, the only scope of adjudication of the issue of default which remained was whether the defendant's tenants complied with the order passed under section 7 within bracket 2. For some next para, insofar as the other ground is concerned, comma, regarding the mandate of section 7 within bracket 2 of the 1997 Act being that upon determination under section 7 within bracket 2, comma, it is the landlord who has to be paid the amount so determined and not to be deposited in the court, comma, we also cannot permit the appellants to raise such issue at this belated stage. Full stop. Next para. The question as to whether the payments were actually made to the landlord or the court is not a pure question but a mixed question of fact and law. Full stop. Since the plaintiffs stroke appellants preferred a revisional application against the determination under section 7 within bracket 2, comma, which was dismissed, comma, thereby affirming the order of the trial court, comma, against which no interference was done by the Honorable Supreme Court in special leave petition, comma, the self-same issue cannot be permitted to be reopened at any subsequent stage. Full stop. The appellants are barred by the principle of constructive res judicata, comma, if not res judicata, comma, from raising the question of validity of the deposits made by the landlords, comma, in terms of the order of the trial court under section 7 within bracket 2 is concerned. Full stop. Next para. That apart, comma, the provision which requires the amount to be paid to the landlord under section 7 within bracket 2 cannot be construed to be so mandatory that it would vitiate the compliance by the tenant of the order passed by the court under section 7 within bracket 2, comma, even if the court directs the amount to be deposited in the court. For sub next para, from the four corners of the judgment of the trial court or the first appellate court, comma, we do not find the specific issue of the deposits being bad having been raised by the landlords stroke plaintiffs. For sub next para, thus, comma, permitting the plaintiffs appellants to do so at this stage would be a travesty of justice. For sub next para, in view of the above discussions, comma, we do not find any substantial question of law raised in the present second appeal. Full stop. Accordingly, SAT 73 of 2025 is dismissed under Order for Rule 11 of the Code of Civil Procedure. Stop. Consequentially, Can 1 of 2025 is also disposed of. No address to cost, urgency referred. The trial court records the decree of the impugned decree be sent down for effecting necessary corrections. Right. Yes. Yes. Yes, Mr.
My lord, I am the defending tenant. My lord, lost before the trial judge. My lord, suit decreed for reasonable requirement. My lord, again, my lord, lost before the first appellate court. Now before your lordship, the property, my lord, is about 65 square feet. A small office on the ground floor of a building which is about G+3. It's about 8 feet by 8 feet, small office. Now, my lord, the questions involved are this.
Yes.
My lord, suit is filed on ground of reasonable requirement where the plaintiff pleads that he has the first floor, he has the second floor, the entire building is his. And on the ground floor, he has his office and he has a go down. So after all this, there is a minuscule amount of space left, which I have. And he says that he needs it for the expansion of his business. To use the property for he says it's suitable for his business to run it from that particular premises. Now, my lord, during the trial, my lord, these facts come to light, and it's all, my lord, there in the judgment that A, he doesn't reside at the building of the suit property. So those floors are empty. He resides at another place nearby, which is his joint family property. But he says that's a joint family property. I own it and I live there, but I own it with some other family members. He doesn't produce any documents for that joint property. There is another property, a 2-minute walk from the suit property, where he is actually running his business and his shops. That is also admitted. So, my lord, in a trial,
he held local inspection regarding the second one.
Nothing. So he has only, my lord, applied for inspection and, my lord, tried to prove, my lord, by way of a commission in respect of only the ground floor of the suit property where my room is located. No inspection, my lord, done for the remaining floors. No inspection done in respect of, my lord, the joint family property where he admittedly resides.
Mr. Lakwani, but joint family property where they reside may not be suitable for running an office.
My lord, may I just say this?
And also ground floor of these premises is better than the other floor. It's his choice, landlord's armchair and all.
No, my lord, I understand those theories, my lord.
Yes.
And, my lord, the other, my lord, place from where he's actually, my lord,
yes, that
running,
he has not held
not, my lord, given any, my lord, evidence. So
he has admitted that in his evidence. That he has done.
Yes, it's there that he's running his business from another shop, 2 shops.
He must have said it's not sufficient.
So no, so, my lord, may I just say this? My lord, the burden of proof would, my lord, always be upon the plaintiff. The onus may shift. Now, my lord, through a trial, if I have brought things to this level on record, that he's running his business from another shop nearby, that he has another joint property, another property which he owns, which he in his defense says no, in his evidence that that's a joint property. He is admitting that the entire building is vacant, that he's living at the joint property. When, my lord, all these things come to surface, my lord, would the onus not shift upon, my lord, the plaintiff?
So, like, how was it dealt with by the trial court, these points?
My lord, the trial court says that I did not apply for a commission. So the entire question is, why would I apply? Number one, the onus is upon him when these facts come to light. Number two, my order 41 rule 27 not dealt with, still pending. And, my lord, the
order 41 rule 27, you tried to bring in what?
I applied, my lord, you have a copy. My lord, it was to do, my lord, with some, it's, I'm told the draft is such, my lord, we can't make head and tail of it, frankly. Because that's the feedback I've gotten.
And how can that be a ground?
My lord, having said that, there is, my lord, an application to bring on.
Cannot make any head or tail then.
My lord, I was candid, my lord, to say that. But the fact is that there was an application to bring on record additional evidence. Now, once that would have been.
Itself would not suffice. I mean, you have to show the relevance of that evidence also to have it admitted on that ground. To have an appeal admitted on that ground, that
I understand.
You have to show that it was German.
My lord, for a moment, my lord, since, my lord,
Let us see if we can make any head or tail.
You have a copy.
So you surrendered all efforts
will-
and did not take that also.
We will, my lord, we will just hand it over. Just find out a copy. So, my lord, this is, my lord, the second aspect. My lord, the third aspect is, my lord, that they have, my lord, in the evidence, my lord, it's found as a finding and it's admitted, my lord, that he wants to demolish the suit property and use my portion to expand the size of the entrance to make it more convenient. Whether this amounts to a reasonable requirement or a fanciful requirement, this urge to expand the entrance, because either he requires it.
Did he give any reason for that expansion? For his go down, maybe it's necessary.
No. For convenience of access. Expansion is not on, my lord, business.
What is the
And the
breadth
business.
of that? What is the breadth of the present gate? Was that brought on record?
My lord, all those findings are not there. It's just said that he's the plaintiff, so he wants to expand the.
Let's see the findings. First.
Yes, my lord. May I also, my lord, one more point? My lord, business. My lord, what is the business? What have they been doing so far? What is the nature of expansion, my lord, conceived? No document, nothing.
Need not. Now need not.
My lord, these are the, my lord, essentially, my lord, the grounds. Now, my lord, if your lordship will consider, my lord, the first appellate court's order. My lord, this is the order, my lord, dated 27th, the impugned judgment.
Width of the main entrance was admitted by you to be 5 feet. Page 20. First
my lord, even your lordship's, my lord, door is about 5 feet. So, my lord, to expand this further, I don't know
what the owners of the property. If we were owners and we are running a business with a go down, Mr. Lakmani, definitely 5 would not suffice. So some reason is there that has been accepted armchair of landlord.
May I, my lord? Kindly, my lord, consider, my lord, page 3.
Invariably, the wrong things come to our eyes. Now, second appeal is basically a defect finding forum. No, but 5 feet, not a fanciful. It is a perception of the landlord which has to be looked into. He's running a business, go down.
My lord, but what is the business? What is the go down? There is not a trace of evidence. Whether, my lord, in such a fanciful case, my lord, whether you have to show something that I'm running a 5-star hotel like the Oberoi Grand, so I need the cricketer's bus to enter through this gate.
You could not think of anything lesser.
My lord, this is an argument.
Ordinary people running go downs.
My lord, we are
ordinary people. You are appearing cannot be ordinary.
No, my lord, we are making this argument, my lord, for removing the hawkers outside the Grand Hotel. So it's fresh in my mind.
Yes, something.
So it's not out of the box, my lord. It's recent.
You are appealing for the hawkers.
No, my lord, for the hotel.
Obviously. How can you?
Lord, I have a senior leading me also.
No, anyway, that's an unwarranted comment. We are sorry for that.
No.
You may very well appear for the hawkers tomorrow. No doubt. So let us see
whoever comes first, my lord, as the rule says. Whoever comes first.
But there are several evidences taken on, considered by the court. How can you overlook these? Let us see.
Your lordship, my lord, will take page 3 for a moment. Now, my lord,
we have come to page 20 of the first appeal. Let us just continue there. Please come to page 20 of the first appellate court judgment.
Yes, my lord.
Because there the trial court's consideration has also been dealt with. That is the last court of facts. So let us start with that. So page 20, the bottom.
Then, my lord, would your lordship consider, my lord, taking it from page 19? If I may request.
Why not?
Yes.
Absolutely. Do that. On careful scrutiny.
In fact, last line of page 18, and then, my lord, last line of page 18.
Very well, yes.
Learned court below did not mention anywhere in his judgment.
This is your arguments continue.
Yes, that the respondent plaintiff is running his business from 2 shop rooms on rental basis, premises number 27A, Gopi Bose Lane, Kolkata, and another from his premises 42B, Madan so and so. By his own admission, the respondent plaintiff mentioned that Tapan Kumar Kaur and Tapas Kumar Kaur are his landlords with respect to the 2 shop rooms. Respondent plaintiff further admitted in his cross-examination that I am...
Those are tenanted rooms then?
Yes, those are tenanted rooms.
He's a tenant there.
Yes, he's a tenant.
That's
there.
not suitable alternative. He's the owner of this premises. He's a tenant there.
I am in occupation of 1 go down and 1 office in the suit building on the ground floor. So the respondent plaintiff is using the ground floor at premises number 16, Gopi Bose Road, Kolkata, as go down and office, whereas appellant defendant is doing his business from another room at the same floor. Now, my lord, your lordship will see the materials in the record are showing that premises number 14, Sakyapada Lane, sorry, Chakrapada Lane,
Chakra is jailer. Anyway, yes.
16, Gopi Bose Lane 27A, Gopi Bose Lane 42B, so and so lane, all situated almost in the same vicinity. Respondent plaintiff has mentioned in his plaint that premises number so and so, Kolkata, situates under postal code number so and premises so and so also have the same postal pin code area, that is so and so. He has admitted that he himself, along with his family, resides at premises number 14, Shakyapada Lane, Kolkata, a residence which is a joint property. The family has not shifted to premises number 16, Gopi Bose Lane, Kolkata. At present, the respondent plaintiff is using the suit building for the purpose of godown and office on the ground floor, but he is not using the first floor and second floor, which have 4 rooms, bath, privy, and kitchen, and he is doing his business from the premises number so and so, Gopi Bose Lane, Kolkata, and from premises number so and so, Madan Bura Lane, Kolkata. May I, my lord, pause here for a moment? So, my lord, there is an admission that the entire building is free for him. It's vacant. And he is admittedly living, my lord, in another property which he owns, but my lord, which he has said that he's the joint owner of. But he has not produced any document to show whether he is the joint owner or not. So, my lord, the onus, my lord, to show whether that is a joint property or not would shift upon him, where he is admittedly the owner and residing there. But he did not, my lord, come forward with any document whatsoever. And then, my lord, your lordship will consider he has admitted that he himself, along with his family, resides at premises 14, so and so lane, a residence which is a joint property. The family has not shifted to premises number so and so. At present, the respondent plaintiff is using the suit building for the purpose of go down and office at the ground floor, but he is not using the first and second floor, which have 4 rooms, bath, privy, and kitchen, and he is doing his business from premises number so and so, Gopi Bose Lane, Kolkata, and from premises number so and so, Kolkata. Respondent plaintiff himself has admitted that he runs a very good and flourishing business from these 2 places. So now he wants to expand the same, and he desires to continue the same on large scale from his own place, that is so and so. On careful scrutiny of the judgment, I have found that learned court below passed the decree in favor of the respondent plaintiff on the ground of reasonable requirement only. Now, my lord, then your lordship, my lord, will come to page 20. Second paragraph. Respondent plaintiff has so, my lord, no issue was framed on, my lord, the question of me having paid my rent. So that's not an issue at all. Respondent plaintiff has brought paragraphs number so and so by amending the original paragraph 14 of the plaint by mentioning that they face great difficulties to enter into the suit building from the main entrance, which is only 3 feet wide. And if he gets back the suit shop room, in that case, he will demolish the suit premises and expand main entrance, and he will also fix the electric meter box in a proper way. He mentioned it further that he wishes to shift his business at the suit building from his rented shop rooms. May I just pause here for a moment? So, my lord, there is no nexus between perhaps the business and the expansion. He says that it is 3 feet wide, and if he gets the place back, he will demolish it to expand the entrance because there is difficulty to enter. That's all that he's saying. Difficulty to enter. And then, my lord, your lordship will, my lord, kindly come, my lord, to this particular, my lord, then some, my lord, law is discussed. And, my lord, towards the end, if your lordship sees at page 32, at page 32.
Hmm.
Second paragraph. You know, this is essentially the concern that I have, which perhaps could be a question of law. On this point, appellant defendant did not file any application for the learned court below or even before this bench for local inspection with regard to the ancestral property of respondent plaintiff situated at 14 so and so in order to find out whether accommodation provided to the respondent plaintiff and the members of his family at the ancestral property is at all sufficient or not. So, my lord, he runs a case that I am living at a particular place. The accommodation in that place is not adequate for me because it is a joint property, and therefore I have to shift into the building which is the building of the suit property. And since I am scheduled to shift in the future to the building on the floors above, the only place that is left for me to expand my business is this little room on the ground floor. So the entire narrative, my lord, starts, my lord, with the alternative property. And this alternative property, my lord, there's not a whisper of this property in the plaint, apart from it being mentioned in the cause title. This entire, my lord, where he's residing, it's a joint, all of that, my lord, comes by way of evidence. So he, my lord, suppresses initially everything to do with that property. My lord, it comes, my lord, to light. So when, my lord, after suppression, if an alternative property which is owned has come to light, and if the ultimate requirement stems from there, that I have less space here, so I will have to shift to the building and occupy, and therefore it will be convenient for me to live and work under the same roof. So, my lord, this entire requirement stems from the main property where he's been living, admittedly. And, my lord, the learned judge says that I should have, my lord, given proof. Now, my lord, when there is so the question I frame is this: when a property, admittedly where a person's living, is, my lord, not pleaded about much in the plaint, and, my lord, when this surfaces, my lord, in evidence, and the person admits, the landlord admits that, yet this is my property, but he takes a plea that it is a joint property. He does not even produce a deed to show that it's a joint property or who's the owner. My lord, he does not produce any evidence. My lord,
you admitted premises number 15 and 17 Gopi Bose Lane are his ancestral joint property. Page 20 of the appeal court. DW1 admitted.
defendant number 1 admitted that premises. No, just one moment. Where have you admitted this? Just kindly, give me a minute.
Mr. Lakman, we are coming back and you just check up.
Wait.
put your house in order.
Yes, my lord.
What have
My
you
lord,
found out?
I must stand corrected, my lord, in one place. My lord, when I accuse them of suppression, in the plaint, my lord, they have pleaded that they are residing at, my lord, the ancestral property. So, my lord, I withdraw that.
No, definitely, we are not going.
Any.
No difficult.
So,
Thank
my
you.
lord, your lordship, my lord, put a query to me that the defendant is agreeing that the property in question, my lord, is an ancestral property.
Yes.
At
Ancestral joint property. That is
yes,
the language.
at paragraph 20. Sorry, page
Right,
20.
right, yes.
Page 20, last paragraph. My lord, may I just place this paragraph? Defendant number 1 admitted that premises number 15 and 17, Gopi Bose Lane, Kolkata, are his ancestral joint property. My lord, here the defendant is talking about the defendant's ancestral joint property, not the plaintiff's joint
17,
property.
17 Gopi Post Lane is their joint property as per their.
No. That is 14 Shakrapara Lane, the jewelry
That's
lane.
a different property.
That's a different property. So this, my lord, is neither the suit property nor the alternative property that the plaintiff has.
All right.
And my lord, the suit, my lord, hasn't been decreed on the ground that I have adequate space elsewhere.
No.
So
That was
therefore,
not even a ground.
so
Right.
therefore, this is inconsequential.
Yes.
So to that extent.
All right.
So my lord, therefore, my lord, just to summarize, my lord, Shakrapara Lane is the plaintiff's property where he lives. He's the owner. He says, I'm not the only owner, it's a joint family property. And the other building where the suit property is entirely owned by the plaintiff. He claims to have, my lord, the entire building, save and except for, my lord, this 65 square feet room. And, my lord, the case that they made out before the trial court was that the office of the plaintiff is run from the son's bedroom. And therefore, in order for the son to have comfort of his bedroom, they want to now have an office here where I am. So, my lord, essentially what are they saying? That I live here, there is a room where the office runs, which is a bedroom. We want an office to be somewhere else apart from the bedroom. This is, my lord, how the trial court's, my lord, order starts. And, my lord, here, when, my lord, he is confronted that what is this other property where you live, you own it. So he says, yes, it's a joint property. He doesn't produce, my lord, any document to show that it's a joint property. He doesn't, my lord, show how there's a dearth of space there for him to continue living there. And this requirement, my lord, in the suit building stems from the dearth of requirement in, my lord, the ancestral house. Therefore, my lord, he has to first show that he needs space because there's a shortage of space in the ancestral house. Only then can there be a requirement, my lord, for him to come to the suit building, because otherwise the suit building is entirely empty. My lord, he can do what he wants there. And, my lord, insofar as the root is concerned, the root, namely the property where he lives, my lord, no evidence given. And, my lord, the learned judge says that I didn't apply for commission. So, my lord, when admittedly there's another place where he's living, he knows that place, he has the deeds, my lord, the onus is upon him to, my lord, lead evidence to show that there is a dearth or shortage of space. So, my lord, it boils down to this, that when there is admittedly an alternative property and the requirement in the suit property stems from or is attributable to the shortage in the alternative property, then whose onus is it to lead evidence in respect of the alternative property, thereby compelling, my lord, the plaintiff to require the suit property, which is otherwise fully vacant, and he can do 5 businesses there unless he has to use it for his residence, which he says he has to because of the dearth of space in the original property.
Mr. Lakman, you were not interfering. You have tried your level best. The present challenge arises out of a judgment of affirmance whereby the first appellate court.
My advocate on record is requesting, if your lordship will just consider, my lord, the 4127, which was not.
But you can't complete confirmed the eviction decree,
my lord,
passed. Confirmed the eviction decree passed by the trial court on the ground of reasonable requirement under section 6 of the West Bengal Premises Tenancy Act 1997. Full stop the এটা দেখে নিয়ে বাকিটা কন্টিনিউ করছি।
Now, my lord, this yeah, one more. My lord, this was on the point of notice there was a notice issued for enhancement of rent. So evidently, my lord, not a requirement. They wanted more rent. And my lord, thereafter, immediately, my lord, they said leave. So this, my lord, issuance of notice of rent, increase of rent itself implies, my lord, that they wanted more money out of us. That's the point.
Next paragraph. Learned counsel appearing for the appellant argues, appellant argues that both the courts below substantially erred in law in decreeing the suit for eviction in view of the plaintiff stroke respondent having not proved the lack of suitable alternative accommodation in the building where the plaintiff allegedly resides as a co-owner. First up, it is argued that the courts below erroneously turned the burden of proof on its head by observing that since the defendant stroke appellant did not take out any application for local inspection to prove the dearth of alternative accommodation, dearth of suitable alternative accommodation, comma, the suit ought to be decreed on such ground. Full stop. Next para, that apart, comma, it is argued that the root premises, comma, being where the plaintiff admittedly resides, comma, was never inspected at the behest of the plaintiff. Full stop. Thus, comma, in the absence of any proof as to whether the said premises contains any suitable accommodation, comma, the suit ought to have been dismissed on the ground of reasonable requirement. So next para, it is further argued that no title deed of the said alternative residential accommodation was produced by the plaintiff at any point of time to establish that it is a joint property. So next para, furthermore, comma, learned counsel argues that the desire of the plaintiff, comma, allegedly to demolish the suit premises in order to expand the entrance thereto is at best a fanciful desire and cannot qualify as a reasonable requirement. For some next para, learned counsel further argues that the plaintiff did not bring any evidence on record to show that the purpose of shifting his business to the suit building would not be satisfied by the upper floors of the self-same building, which were never inspected. Full stop. Next para. Learned counsel next argues that in the absence of any proof as to suitable alternative accommodation not being brought by the plaintiff on record, comma, the courts below erred in law in accepting the ground of reasonable requirement. For some next para, lastly, comma, learned counsel points out that despite an application for production of additional evidence under Order 41, Rule 27 of the Code of Civil Procedure having been filed by the defendant stroke appellant before the first appellate court, comma, the same was never taken into consideration. Full stop. By way of such additional evidence, comma, the defendant stroke appellant sought to bring on record notices by the plaintiff stroke respondent to enhance the rent, which would go on to establish that the interest of the plaintiff stroke respondent lay in enhancing the rate, and as such, comma, the ground of reasonable requirement is a mere ruse. Full stop. Next para. Taking into consideration the arguments of the appellant as well as the materials as well as the judgments of both the courts below, comma, however, comma, we are unable to accept the contentions of the appellant. For some next para, both the courts below scrutinized the evidence on record and on the premise of the oral evidence adduced by the plaintiff's witnesses, comma, came to the conclusion that the plaintiff had established that he is a co-owner and in joint possession of the residential accommodation available to the plaintiff. For sub next para, by no stretch of imagination can an undivided joint property be said to furnish suitable accommodation or exclusive right to occupy a particular portion of such premises. Full stop. Next para, thus, comma, we cannot fault the reasoning of the courts below on such count. Full stop. Next para, moreover, comma, it has come out from the evidence of the parties that the two shop rooms where the plaintiff stroke respondent is currently running his business are both tenanted accommodations, comma, which cannot compete with the own property of the plaintiff insofar as suitability of accommodation is concerned. For sub next para, the requirement of the plaintiff to demolish stroke reconstruct the suit property to widen the entrance cannot also be disbelieved altogether in the teeth of the specific finding of the courts below on the basis of an inspection held at the behest of the plaintiff that the existing gate is of about 4 feet width. For sub next para, the plaintiff stroke respondent, comma, in effect, comma, seeks to shift the business being run by the plaintiff currently into tenanted accommodation in a composite manner to the suit property, comma, for which purpose the plaintiff has made out a requirement to enlarge the gate, the existing gate of the same. Full stop. That apart, comma, irrespective of whether alternative accommodation is available on the upper floors of the suit building, comma, the purpose of business and widening the gate would only be subserved by the ground floor. Full stop. Thus, comma, the non-examination, the non-adduction of any further evidence on the part of the plaintiff stroke respondent insofar as suitability of the accommodation available on the upper floors of the suit building is concerned, comma, is not germane for the present purpose. Full stop. The courts below considered such aspects of the matter and also came to the conclusion that in order to shift the electric meter box, comma, which is now situated within the house, comma, at a proper place of the suit building, comma, the plaintiff requires to reorient and, comma, if necessary, comma, demolish the suit building for the purpose of bringing his business there. For sub next para, since the above questions involve appreciation of factual evidence on record, and both the courts below have arrived at a concurrent finding in that regard, comma, it is not for the second appellate court to interfere with the same. Full stop. Next para, insofar as the application under Order 41 Rule 27 is concerned, comma, even if allowed, comma, the same would not be germane for the present context, since the mere notice on the part of the plaintiff stroke respondent to enhance the rent cannot tantamount to conclusive proof that the plaintiff does not require the suit premises for his personal requirement. For sub next para, in such view of the matter, comma, we do not find any substantial question of law involved in the appeal sufficient to justify admission of the second appeal. Full stop. Accordingly, SAT 110 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 is also dismissed. No orders to cause urgent certificate course. Sorry.
It's grateful.
Okay.
I was just telling my advocate on record that the rules require a second appeal to be heard out by a single judge. But here he's had the benefit of a division bench hearing out the second.
So rules require a division bench to
admit, and then
hearing. Yes.
Grateful.
This is the reason. What just happened?
Grateful.
That is the reason, Mr. Lagmani, to screen out, to have two brains to consider whether, because the language of Order 41 Rule 11, you know, whether it should be dismissed. So
No, no, we are grateful, my lord. We are grateful for
no,
the
no,
hearing.
no. Thank you. You argued very well, but you could not find out any point, substantial question.
Grateful.
Thank you. Next.
For the respondent number 2.
Lordships are being led by Mr. Shudhashato Banerjee in this matter.
Lordship,
The Lordships are aware
and for
that
the respondent number 1,
Yes.
there has been a serious bereavement in his family. So I'm
When should you keep it? When should we keep it?
tomorrow, like not today would be, we're simply paying for the not today.
Mr. Shudhashato Banerjee's ground, Mr. Sinha.
I am not going anywhere. The day
We are
after,
adjourning for the day only.
your lordship will keep day after. I am personally not so. The day after is. If
We'll
it's
keep it
not-
next week because day after we'll be taking up hearing matters. We are taking up now on Wednesdays, and
When you will next week, then your lordship will keep it next week.
an adjournment is sought on behalf of the appellant on the personal ground of learned counsel appearing for the appellant. Full stop. Accordingly, let the matter stand over till July 20, 2026. Thank you.
Okay. No, sir.
এরা তো appellant. Mitra, what is the matter?
Well, I'm a defendant in the suit claiming tenancy right.
Right.
A decree of affirmation. In both courts I have lost.
No, defendant in a suit claiming tenancy, you have been admitted to be a tenant. It's an eviction suit.
Defendant in the suit. The plaintiff claimed tenancy right against me.
Oh,
the plaintiff, sorry, the plaintiff.
In a suit claiming.
Yes, in a suit claiming tenancy right, I am a defendant.
So both the courts decreed this.
The court decreed, they added, subsequently, they added a prayer for delivery of possession also. Initially, only tenancy right.
But during pendency of the suit,
Pendency,
you
they say I have
dispossessed.
dispossessed. A miscase was filed, everything happened. And then they now seek, so we went to Supreme Court. Supreme Court said, no, you could not be able to prove your possession. I am in possession. Supreme Court from 2006. Now the suit restoration possession was given. Today the order was passed declaring they are tenant and put them in possession. Now the strength of the document.
No, Supreme Court was during pendency of the suit,
Yes.
that cannot be restored. So that is not conclusive regarding.
No, I'm not. But Supreme Court in the order, what has done, they have framed 5 or 6 issues, which has to be decided by the trial court. So according to me, those issues have not been decided conclusively by the trial court. Be that, my lordship will kindly the supplementary affidavit, the document on which the sheet anchor of the document, which is the purported tenancy agreement. Page 35, volume 1 of the supplementary affidavit.
The spelling of sheet will be defined by the quality
Yes,
of the
by-
evidence.
yes, by the quality of the evidence.
Yes. Supplementary affidavit. What is that?
Last day, man, we have given liberty, we have filed, man. It was filed in court, man.
The supplement. The volume 3 state. এটা হবে। এগুলো কি supplementary affidavit?
No.
All these volumes are supplementary affidavit?
Right.
Yes. So which page?
35. Yes. Some of the important document got missed, man. It was added later.
All the important documents got. Yes.
Now,
Sati warrior for the respondent, caveat. Yes.
Now, this is the document on the strength of which the plaintiff claimed they are in possession. Now, the first thing, Malad, I'm attacking this document on several levels. First is, this document so far my signature is concerned, this Khaitan's signature is concerned, we have said this is my signature. My case is, a blank document was given to him. I knew him for some time. Evidence has been led that I have lost some traveler's check. For that, I've given it to, because I knew the plaintiff for making a police complaint. And he has converted this to a tenancy agreement. Second, this Khaitan Paper Machines Limited has nothing to do with the property in question, not the owner of the property. It records another entity called Khaitan Estate. This Khaitan Estate, it records I am a managing partner of Khaitan Estate. I am not
Letterhead is of
connected.
that machines, but he signs as managing director and partner of Khaitan
Yes,
Estate.
I am a director of Khaitan Estate, but I am not a partner of this company, of this partnership firm. I'm not a partner.
Khaitan Estate is a partnership firm.
Partnership firm, I am not a partner.
This document says that.
Yes, what I do, I have signed it for giving to the plaintiff a blank document for making complaint to the police.
Now he has typed this later. Why I say? This document says that 2 lakhs of rupees was given as a security, a property of 7,000 square feet with a rent of 7,000. Now there is no averment in the plaint. A rent for a single day was paid to me. No. There is no averment in the plaint that once he takes possession of a 7,000 square feet area in the second floor of a complex, he paying electricity, nothing, no averment. He is paying maintenance, no averment. He is a member of the association or informed the association that he will now in possession, nothing. The association secretary came to the box, my witness said that existence of this gentleman or any, he is in possession of any banquet or unit in my housing, I don't know. Nothing is decided by trial. The first appellate
Not
court.
a single rent receipt.
No, he's not even case in the plaint. Not a single rent receipt, nothing, no averment in the plaint. That I've paid a rent waiver. Even here, a 7,000 the document does not record the square feet. It records the entire second floor, which is 7,000 square feet.
Maybe, I mean.
Maybe, whatever. So the rent is unconscionable. This fact is recorded by the Supreme Court also. Now, no tendering of rent. Now, if you go further, my lord, on this day, 17th of April, I have shown travel documents. My air tickets in Air India, 1998. Air India people came to give witness. I was in Delhi. I was in hotel in Delhi. The Delhi people, the secretary, the gentleman from the hotel came and gave evidence that I checked into the Delhi hotel.
On this date?
Yes,
17th of
yes,
April.
on 16th. On 16th, I was in Delhi.
16th till?
Previous date.
On 17th, I left the hotel.
At 2 p.m.
I'll tell you. 16th, I checked in. 17th, I left.
You left and took a flight.
I not tell. The travel document says that the hotel document says I left the hotel at 2 p.m. The plaintiff's evidence says it was signed at 9 a.m. in the morning at the petrol pump in Howrah, in Calcutta. I left the hotel at 2 p.m. The hotel document says. The travel document, my boarding pass, my ticket shows that I availed a flight, which flight reached Calcutta at 9:30 at Dum. Now, when the question was put to the witness of the hotel person, he said that our checkout time is 12. There are 2 rooms booked. So we said 12. But any event, whether I'm in Delhi on
Plaint case is 9 a.m. In the plaintiff stated or in their evidence?
Plaint case in the evidence. Evidence.
Let's just check up where it is.
In the evidence. In the evidence. Evidence specifies 9 a.m. at Shalkia. This is one petrol pump. And I have signed. It goes further. Any event I could not have been in, whether I was in flight or in Delhi, I could not have been in Howrah. It goes further. So these documents, all evidence has been laid.
I have filed a suit.
And I have filed a suit after coming to know of this document. I have filed a suit, delivery upon cancellation, which is pending. Same court. Analogous hearing, there's one order I heard. I have not seen the order, I must say. But nothing was done. That suit is pending. When I have challenged this. Now
those were analogously heard.
No. It was decreed.
But you mentioned this suit during.
Yes, it's recorded in the order also. Impugned order also. It's recorded. Now this, and it goes further. Evidence says this document was prepared on 16th in High Court area.
Whose evidence says?
Plaintiff's evidence. Plaintiff's evidence says that this document was prepared in
Might
High
have
Court.
been. Might have been.
Might have been. It also says where my lawyer has put in some of his legal words. But I was not there because I was in Delhi in any event on 16th. In any event, I was in 16th. Who is the name of the lawyer? I don't know.
Everything else could be done, Mr. Mitra. It might be that you were in Delhi, but your lawyer did whatever prepared, was a part of preparation of this document on 16th.
Now, rent. First of
But
all, signing.
Signing on 17th at 9
Yes.
is doubtful
None,
as per what
and no rent paid. So 107 of the Transfer of Property Act, my lord, this last. This document does not contain the signature of the tenant, the plaintiff. It bears signature of witness, but does not bear the signature of the plaintiff, the tenant, the so-called tenant. No explanation that why this does not bear a signature. Lordship will see one page. It typed in such a way.
Unilateral document, unilaterally as if you are giving it in it.
I am giving a tenancy.
So that could be their signature is not a
See,
signature.
I'm giving all the facts. I'm
Casts
giving
a doubt
all the facts.
as circumstantial.
No, I'm giving all the facts.
All right.
Now, this 2 lakhs rupees was paid. The document says 2 lakhs was paid as a security. 2 lakhs as a security.
No receipt, nothing.
No receipt, nothing. Plain case continues that I approached him and he gave me a loan. Paragraph 3 of the plaint. That he gave me a loan. What happened? This property, the plain case runs, this property was in possession of a different tenant. One Mishra. And then I knew this gentleman. The plain case shows that I had to pay Mishra 2 lakhs of rupees. I didn't have money for renunciation of his tenancy.
You took 2 lakhs from
I
him?
took and gave it to him. That's the plain case. And then he says for 400 square feet of Mishra. He takes away 7,000 square feet from me and this money of 2 lakhs of rupees and gave it that the plain case runs. And the plain case runs. So this, and moreover, this company, the Khaitan Machine Limited, is a listed company at that point of time. A listed company's letterhead being used. And this document, Lordship will see, has been typed so in the fashion that the entire.
Were you a part of this Khaitan machines also?
Yes, that is true. This Mr. Khaitan is part of this Khaitan machines also. So this document, if you look into the document, the original, there are some police proceedings going on because I have made this police complaint. Now the photocopy of this has been given on evidence. No effort made to bring the original. When the police comes and has produced, has given a seizure list, which shows that the original has been taken over by the police. The seizure list is produced. Now, this matter came in a 227 proceedings once before your lordship. When they tried to bring in the original, it was dismissed by law. Neither whatever. Now, on these documents, my lord, and the no consideration.
How were these points dealt with by the courts?
Whether these points. Lordship will kindly come to the impugned order, which is internal page 32.
Should you look into the appeal court judgment first?
Yes, appeal court judgment.
Page 166.
It starts at 166 of the stay application.
We are following the internal
memo appeal. She is following in the memo appeal.
Yes.
So I'll just refer to the internal page because
that will be easier.
Some
no trial court we have. Let us find out the appeal
trial
court.
No,
Yes. We have found out the appellate code also.
Appellate code.
So yes, internal page.
Internal page. It is dealing from page 32. As regards. As regards to another ground to challenge, the said document of tenancy, that is unilateral document which cannot be considered as an agreement for tenancy, as it requires certain terms and conditions for creation of tenancy, as also requires signature of both parties as agreed by the learned advocate for the appellant. It is pertinent to mention here that the appellant has not challenged his signature on the said document. On going through the said document, Exhibit 1, it can be found that the appellant has acknowledged receipt of rupees 2 lakh as a security deposit from the respondent for inducting him as a tenant in respect of the entire second floor of the ground floor of the address at a monthly rental of 7,000 only, payable according to the English calendar month for running business or letting out the same for ceremonial or business purpose. There are other conditions mentioned regarding completion of plastering. Here he records, therefore, the said document can be considered as an acknowledgement of receipt of 2 lakhs. Because I have put my signature. But I admit my signature, but I said it blank. From the respondent as well as written acceptance of oral offer of the respondent for taking the premises on rent and its acceptance by the appellant. From the evidence of PW1 during cross-examination, it revealed that the proposal was of oral form and not in writing, and the acceptance of the defendants was also in oral form. From the evidence of Mr. Shomadar employee, it has gone in further, Malad. The next page, Malad, here. The page 33. He has identified Exhibit 1 as a document of compromise, and the respondent typed near the Calcutta High Court area, and on the next day, that is on 17th, the document was signed at the petrol pump of the respondent at 9 to 9:30 a.m. And at the time he was present at the petrol pump of the respondent, and that Shivanand has paid, and Shivanand was paid 2 lakhs to vacate the area under his possession. After that, they came to Ganganchal, and he has revealed, Malad, 5-6 lines below this. It also revealed during cross-examination that the money receipt was prepared for the amount of 2 lakhs, and he had seen the money receipt. From his evidence, nothing is found doubt in his version. On the contrary, the date of handing over the blank letterhead on 25th of April, as mentioned in the plaint in 153, this is my plaint, by the appellant also found true after receiving phone call. Then, my lord, after this, the dealings, further dealings in paragraph page 36, the internal page 36, which is 107. At the time of hearing of the appeal, then an advocate for the appellant raised some important proof of tenancy, Exhibit 1, as not an agreement, as it do not contain the signature of both the sides, and also the terms condition of tenancy. It is also submitted. The rent receipt is an important document for establishing tenancy, but no rent receipt has been filed by the respondent. It is also relied upon CHN and submitted that the tenant can approach the rent controller for the rent receipt as per the provisions, where the landlord withholds and do not issue any rent receipt. It is absence of rent receipt, the claim of tenancy cannot be believed. Now, the strongest proof of the strongest proof of tenancy is the registered deed or the registered tenancy agreement containing terms like rent, duration, right, obligations. There is nothing here. Another document is rent receipt issued by the landlord acknowledging payment. Utility bills such as electricity, gas, water cannot be treated as document of occupation. This is the only document that can show.
So, Mr. Please show us
the last line, my lord.
Yes.
Neighbors of this para, neighbors and third parties can also confirm occupation and payment of rent.
These are not very convincing. But how were your evidences dealt with? Those air tickets and all, you exhibited those?
Yes, all exhibited. Air tickets.
So Abel Court does not deal with those?
Yes, Lordship will see. This is internal page 31 then. How they have dealt with my air tickets. Yes. Just idiot. No. Internal page 31. My air ticket.
31.
31. The appeal court. As regards air journey of Mr. Khaitan, in order to establish his absence on the date of creation of Exhibit 1, he has relied upon the evidence adduced in the misappeal and the documents produced in the said misappeal, and also these are the exhibit marked. Lordship can mark from page 46 to 49 of the papers here. The Shamol Mukherjee deposed on behalf of Indian Airlines, Calcutta, and his evidence during cross-examination, it has been revealed that neither at the time of issuing the ticket nor at the time of boarding there is any system of checking at the airport as to the person in whose name the ticket was purchased was boarding the plane for domestic flight or not. Similarly, in the said case, Amitabh Gupta has deposed in support of the flight return statement, and during his cross-examination, he has revealed that in the said statement there is no mention of the name of the person took the flight against each flight return card. Anyone can purchase the ticket in Indian Airlines in the name of Kishore Khaitan just on production of flight return card. On going through Exhibit F, it can be found that the said boarding pass in the name of Khaitan / K. Mr. in respect of flight number such and such from Delhi to Calcutta. The flight ticket was produced marked respect of from Delhi to Calcutta. Therefore, there remains considerable doubt as to the plea taken by the appellant that on the day of creation of the alleged tenancy, his presence of the petrol pump is not possible since he has landed in Calcutta at 9:30. Now, the gentleman from Air India came. He said that is the system, K. Khaitan. There is no.
This was elaborately dealt with. The evidence was appreciated.
No,
we are telling you, your flight ticket, the flight number does not match with the boarding pass that has been found by the appellate court.
The flight
ticket which has been produced, IC 401 and IC 264. The flight ticket in your name and the boarding pass are for different flights. Now secondly, as per the evidence you produced, you should have reached Calcutta by 9:30 a.m.
9:30.
Which could not have been possible if the hotel person was correct. You left at 2.
No. What happened? I'll just check you the document also. I'll just complete this parameter. It is not sure whether It is not sure whether the appellant traveled by the said flight or some other person traveled on the said boarding pass. Remember, there is no contrary evidence showing that some other person has. The court is coming to a finding on surmise and conjecture.
No, your witness, the hotel personnel.
No, I'll come to the hotel. It is also not clear why the boarding pass and ticket is not the same flight. Because I took the next flight, madam. As regards the evidence of Rajiv Mishra, an employee of Delta Sheraton, and the document exhibited, Mr. Kishore Khaitan left Delta Sheraton on 17th at 2 p.m. This document goes against the appellant and destroys his story of availing the flight of 401 reaching Calcutta at 9:30. If Mr. Khaitan left Delta Sheraton, New Delhi at 2 p.m., question of availing the said flight and reaching Calcutta is not possible. The question of me signing the document is important. One will have to be going. Whether I've took the flight, if somebody else has taken the flight, then I'm in Delhi. Both, I can't
Your
lose in
case
both.
is mutually destructive. Your
No,
evidence.
it's not that, brother. Lordship, kindly see the
Still
document.
person says you left
No,
Delhi
Lordship
at
will see
2.
the document. The
At
document,
9:30 a.m. you reach Calcutta.
page 44
Your
of
boarding
supplement.
pass is of that flight which reached Calcutta at 9:30.
No, I'll tell you.
See,
I've
Mr.
given.
Mitra, IC 401, your boarding pass tallies with IC 401.
Yes.
Boarding pass is of IC 401,
Mile.
which admittedly reached Kolkata at 9:30. Because if you see the middle of that page,
Yes.
page
So
31,
I took IC 401. My evidence
and
was
that reached Kolkata at 9:30.
9:30.
And then how could you leave Sheraton Hotel at 2?
Yes. Lordship will kindly see the
The evidence
document.
demolishes itself.
Documented, see the Sheraton document.
This is absolute appreciation of evidence, and it went against you. Why should we interfere?
No, the next aspect is the document, the Sheraton document. It shows that the departure time at 2 p.m. because that is the schedule entry
The
time
hotel
and the exit
personnel
time.
came and adduced evidence to say that you have left Delhi at Sheraton at 2.
No, in here there are 2 rooms. The document says 2 rooms have been booked. Kishore Khaitan plus 1. So the witness says, I do not remember everything, but only on this document 2 persons were there. And if I have availed this flight, I was not in Calcutta on that day. Now, and the document was signed by me.
Your own
the
evidence
witness-
is mutually destructive on that. That is the
can't-
plinth of your case. You
it
could not
can't-
be in
huh?
Calcutta.
Now on the page 38, which is on letterhead point, how did they deal with the letterhead point? Now, even if this is now the secretary of the association, which is saying that he was never in possession, that is not dealt with at all. So this I have showed you, Lordship, with this, but Lordship is not with me, that I was traveling. Now page 37, page 37.
38.
Page 38. Yes.
38 paragraph.
Page 38, exhibit 39 is the Xerox copy of the letter of delivery of possession on receipt of rupees 2 lakhs by Shivanand Mishra, also bearing the signature of registrar K. Khaitan. The said document was created on the letterpad of Khaitan machines. That is, similar letterhead on exhibit 1 was created. As such, the argument of the learned advocate for the appellant that Khaitan machine.
There's a letter of delivery of possession also independently.
That same agreement.
No, the same document. The same document. Delivered by the same document. Same document. Khaitan, the 2 different entities, and the letterhead of Khaitan paper mills cannot be considered as a proper document of creation of tenancy in Ganganchal complex.
No, exhibit 1 is that document.
Exhibit 1. Now, exhibit 39 was a document which is present.
Letter of delivery of possession.
This is of Mishra. This is of Mishra, not of this judge. This is of Mishra.
But it was also created in similar letterhead.
This was also the Mishra document. This was page.
That is a finding.
Page 44A.
So that's your modus operandi. You use the letterhead of that entity.
No, page 44A, Lordship.
Shivanand Mishra's tenancy was also created in that fashion.
This document is on record, the 44A document. This is also on the paperhead. Now, point is that
same letterhead.
This document, point is, this paper, I have signed this document, the document exhibit 1, which I have signed document has been converted. I was not in Delhi on that day. There is no tenant, there is no, somebody has been put in possession. He has taking away possession from me. Now, even the Supreme Court order records, these has to be gone into. I'll just show the Supreme Court.
Show us the Supreme Court.
The Supreme Court order, my lord, this is page 38 of the stay petition. Yes, page 38. Now, no payment of rent, no proof of occupation. The maintenance, electricity bills, nothing. Association membership.
Once the commencement of tenancy is proved.
That's if the best evidence is withheld to prove possession. If there is a plaintiff's case, he has to prove possession.
A tenancy is created, the termination of that has to be shown by you.
But he is now asking back possession from me, and he says he has been dispossessed. For that, he has to prove that I was in possession, which Supreme Court has said. So, to being him in possession.
38.
Well, no, it starts at page, the internal page, it starts at page 20, page 31. 21. It starts at 21, the portions at 38.
Stay application.
Stay volume 1, yes. Stay. Stay volume 1, page 31, the order starts of Supreme Court order. I am at page. Stay to. Stay.
এটা হবে অন্য জিনিস
Can.
এই যে এটা ক্যানটা
Page 31B.
Yes, 31.
Now, after detailing everything,
Went up from what, Mr. Mitra?
This is with regard to the possession, because he asked for possession immediately back, and then
that was granted to them.
Granted by this court.
You challenged that.
By Supreme Court, disposes them and gave me back possession. Now, page 38, internal page 8 of the order, after the two pages here.
Yes.
After few lines, the burden is that
in that
behalf is clearly on the plaintiff. The claim he made having denied by the defendant. Therefore, the first question that the district court had to consider pursuant to the order of remand by the High Court was whether
it was previously remanded also.
It was once remanded. Not when the mandatory injunction was, they got the mandatory injunction, not the final decree was remanded. Not the final decree was remanded.
So this the Supreme Court is referring to the district court considering in respect of that repossession application, not this
on the repossession. But Supreme Court has gone ahead and making some observations. Considered repossession, yes. Prima facie established that the building was let out to him as claimed. The building is seen to be of substantial dimension within the district of Howrah, part of the city, commercially important. Prima facie, it is difficult to imagine that such a building on the second floor of the part of the ground floor of the building of this nature would be let out in such an informal manner, and the transaction is not being evidenced even by a rent deed executed by the lessor and the lessee in terms of 107 of the Transfer of Property Act. What the plaintiff has relied upon is seen to be a letterhead of Khaitan Paper Mill signed by the first defendant described as managing director and partner of Khaitan Estate. Prima facie, it is seen that whereas the letterhead is that of Khaitan Paper Mill, obviously a limited company, the signature is that of the managing director and the partner of the estate, an entity different from the Khaitan Paper Mills Limited. It is difficult to imagine that the letterhead of one company was used dealing with the properties of another entity, which appears to be a partnership firm, as per the description contained letterhead. Secondly, the letter purports to be an acknowledgement of receipt of 2 lakhs as security from the plaintiff creation of tenancy, inducting an in possession in respect of the entire second floor at a monthly rent of 7,000 and conferring upon the plaintiff
what was held only regarding the suit was genuineness and validity of the document has to be decided.
In question, and it records that 107. Prima facie.
Those are all prima facie.
Yes, I know it's prima facie. The last
regarding the suit, the only observation is one of the questions that has to be decided is whether this letter is genuine, etc., for the purpose of the suit. Admissibility in evidence and validity have to be decided in the suit. So that is the only finding regarding the suit which has been done.
But it continues for further. Prima facie, the document does not satisfy the requirement of 107 Transfer of Property Act. And though it acknowledges receipt of a sum of 2 lakh, there is no stamp affixed to indicate that it was intended to be a receipt for the said sum. As noticed, the rent stipulated is 7,000. Suffice it to notice that the genuineness of this document, which is seriously disputed by the defendant, is admissibility. Therefore, one of the questions has to be decided whether the letter is genuine, and if it is genuine, whether it is capable to bring the existence of a lease or acceptance as evidence of a lease in transaction between the parties. Now, this part is not answered in view of section 107. And there is no evidence, no finding that why everybody signed, some witness even signed. And why didn't the tenant sign, the so-called tenant, on the document?
TP একটা দিন তো ট্রান্সফার প্রপার্টি
TP
বইগুলো আমার মনে হয় নিচে কোথাও রাখলে ভালো। ওই দিচ্ছেন উনি দিচ্ছেন। আর আরেকটা ওই দিচ্ছেন উনি তাতে ল্যাঙ্গুয়েজটা একটু দেখে নেওয়া দরকার আছে।
A lease of immovable property from year to year or for any term exceeding 1 year or reserving an yearly rent can be made only by registered instrument. All other leases of immovable property may be made either by registered instrument or by oral instrument accompanied by delivery of possession. So it has to be. Now,
This is not a registered instrument,
this is not an instrument.
nor is there any delivery of possession proof. That is, but in the document itself, delivery of possession is indicated.
Yes. Now, if I dispute the document, the onus is on him.
You dispute, but that has been believed by both the courts on evidence, Mr. Mitra. That is the difficulty. The document itself has been treated to be the document of possession and
Now-
receipt of.
Not to show because he says he's
It's on
dispossessed.
an appreciation of the entire evidence, your air tickets, everything.
That the court
There
has
is no perversity in as much as your evidence is not considered at all or something like that.
I say, my lord,
Full-fledged.
huh?
Erroneously considered.
No, erroneously considered is that's perversity, man. And the association, first is no rent paid. Second is he is in possession. There is no proof that he is in possession. Any documentary proof. He is running a banquet. So first of all, he will have to pay me rent. Second, electricity, because the document says you get a submeter. You have to consume electricity. That is the basic thing if somebody is in possession. There is nothing that he's used the submeter. He has to pay maintenance. He says, I run a banquet. There has been one rice ceremony or something, or somebody comes in. So some electricity consumption, nothing. He have to prove that he was a association secretary has been informed. It's not a standalone building that somebody can go in and open the door and use the property. The secretary of the association himself recorded that there is nobody who was the secretary then also.
If that document is believed, a tenancy was created, Mr. Mitra. That's a difficulty.
Now, if the document is with, here it says if it is not registered, and second is it has to be coupled with delivery of possession. Then to show delivery of possession, I cannot prove negative. He has to show that he is in possession and
Document
using the
itself
property.
is there. The document says possession.
Document is there. Now, once this document, then thereafter,
Believed.
now thereafter, because he's saying dispossessed. And then what thereafter? He was in possession. He remained in possession for 10 months. For 10 months, he remained in possession. No rent paid to the rent controller. No rent tendered to me. That's not his case.
Have him evicted.
No, thereafter,
Process of law.
when he got possession, my lord, when he got back possession pursuant to order of this court. And there was a 10 months timeline because from this court to the Supreme Court timeline. Nothing. Then he amended the plaint after Supreme Court order and got the prayer added for restoration of possession.
No, then what did you go up against before the Supreme Court? We thought that against that restoration order you had gone up in Supreme Court.
Yes. No.
You say after Supreme Court they have amended the plaint and
Yes, after Supreme Court they amended
in the plaint there was no amendment,
No.
but they made an application saying that you have been dispersed.
They made an application 39-4 miscase. The miscase went up. So now here, my lord, after Supreme Court, they
Case on the ground that you had violated an injunction.
violated the order. Yes, he said violated the order. So then Supreme Court said you restore back the possession to the owners, the landlord. The Supreme Court said. So from 2006, my lord, I am in possession from the Supreme Court. So today, and the evidence of the secretary of the association that has been dealt with at all. Any even when I come back to the document of my travel document.
Difficulty, Mr. Mitra, is all these documents have been elaborately discussed by the
I know, Malay. If it is perverse,
appreciation of
I know
ethics.
I've lost in both the courts. But still, if I 7,000 square feet in Howrah, my lord, somebody is in, and Rashid, kindly see the document.
Ask for the rent, have him evicted, do whatever you like. But tenancy has been established by both the courts. On consideration of evidence on the basis of a document, it has been established before the courts that in a previous agreement with a different tenant, you use the same letterhead.
For the other one. Now, I say the travel document, Rashid, kindly appreciate.
Travel documents have been considered.
I've been considered, but I say
401 boarding pass,
no,
which reaches Kolkata at 9:30. Your hotel personnel comes and says you left Delhi at 2 p.m.
So, Lordship is kindly look in different angle.
Different angle.
Why else? Will kindly. Will
You have to
kindly.
reverse time.
No. In either situation, I could not have been in Howrah at 9 to execute the document. I could not have been in Howrah at 9 a.m.
You demolish your entire case of you being in Delhi if your
No, it's
evidence is
not that.
mutually exclusive,
I'll tell you
that's
why.
the difficulty.
The witness of the hotel in Sheraton,
Your
he
flight
has
ticket is of a different flight, boarding pass of something else, some other flight.
Lordship will kindly then come to the document, which is the travel document, how the document
We
says.
won't look into documents now. It has been considered by both.
It has been considered. The document says the plane, because what happened, my lord, I am a frequent traveler. So I have a ticket of the earlier flight. I boarded the next flight. The travel document said the flight which I boarded, of which I have a boarding pass, that reached Calcutta 9:30. Even if I go back, go back the ticket.
If the flight ticket corroborated, because flight ticket is in your name.
Boarding pass also in my name.
K Khaitan. There may be umpteen K.
No, there's the presumption of the court. That's the presumption of the court.
Even if that
that's a
was
system.
true, even
Today,
if that
Malak,
was
we
true, we
have
go
the-
by that. We go by that. The boarding pass. You reached Kolkata at 9:30. Your person says you left Delhi at 2. Hotel at 2.
No, hotel said he checked out time at 2. He did
So
not say that I
it-
left.
You might have
the hotel
it might
said
have
the
been a case of overkill on your part, but you should not then have brought that evidence.
The document says the departure time at 2. They left the hotel.
You have a different bench, Mr. Mitra. We are dismissing your appeal. Sorry.
No, my lordship will kindly give me some time in further. My lordship in a
We
hurry.
will continue at 2. এইগুলো এরকমই রেখে দেবেন, এখানে যা আছে এরকম ভাবে থাকবে। নোট ফোট নিয়েছি। Yes. Yes, Mr. Mitra.
Let one thing on facts. There was one document which is the alleged money receipt of Shivanand Mishra, on which my lord's comment was, this my modus operandi as he's using the letter.
That is the finding that the modus operandi was our coin.
No, my lord, sir. So on this document, first of all, this document, a photocopy was produced. Specific ground in the first appellate decree, this is a forged document. Why I say, and there is no finding. Why I say,
whatever document is produced against you, either forged.
No, because this is why I'll say the photocopy is given. I said this is a forged document, no original is produced. And in the compromise petition before the court, when the Shivanand Mishra and myself, there's a recording that he has voluntarily given me possession. There's nothing on 2 lakhs of rupees given. Now, so far this document is concerned, now if I pay somebody, he will give me a money receipt. It comes on my letterhead. It cannot be on my letterhead. Now the compromise petition records that I voluntarily given up possession. The compromise petition. This money receipt, I say this is a forged document, ground taken. Now, so this khaitan and this letterhead is being used. This is the first. Second is how the plaintiff came into the property. He is not a rank outsider to the property. I appointed him as my agent for renovation. That's my written statement case. I have paid him certain money for renovation. Document in support of payment on record, exhibited. Court submissions are recorded, there is no finding. It is not the plaintiff is a rank outsider to the property, he has just trespassed into the property or has just broken the lock and gone in. He is my agent.
So, if he was your agent and you have put him, asked him to renovate, then you, in a sense, you admit that he was in possession. In whatever capacity.
As my contractor to renovate the property.
But then you admit that he was in possession.
Not as a tenant.
You
Not
are
as a
denying possession in the one hand.
I am
Possession that he
denying
was
possession.
never in possession of the property.
No, he was never
Now
in
you are saying
possession.
possession, but in a different capacity.
No, that's my. Well, I told him, please renovate my property. That doesn't mean I'm giving him possession to stay in the property. A contractor, if I asked you to make a renovation of my
But
room,
that he was
it is
put
not
in
that I'm
possession
giving
by
him
you, that is
possession.
admitted by you.
He has a limited access to the property. It can be for renovation.
Someone renovate without having possession.
No, that can he now changing his nature and character to his being a tenant. He uses a blank letterhead and converts to a tenancy agreement. He says that 2 lakhs of rupees I pay the security, and then he starts enjoying the possession as a tenant. And the plaint case runs. If I show you the plaint, the 2 lakhs of rupees given as a loan. That's the plaint case. Your Lordship, kindly. So this is on the document of the money receipt, a photocopy produced. I said this is a forged document because the compromise petition says that nothing was paid. And the ground number 14 of the first appellate decree, from the first appellate decree, I have specifically said that this is the forged document. There is no finding in of the court. And the plaint case, my lordship, kindly come to the plaint one. This is the last. I'll just take you. The plaint is at stay application, the CAN, volume 1, page 87. At 87, 87, the plaint case. Paragraph 3 and 5. Copy. On 8th of April, the defendant had been in the business place of the plaintiff and requested him to accommodate a friendly loan of 2 lakh rupees for their urgent need of business. They had disclosed that their guard of Shivanand Mishra instituted a suit in civil suit, which is a suit of Shivanand Mishra, for declaration injunction against the defendant. Then, my lord, it continues. I think there's the second page is repetition of the page. We'll can you turn over, my lord? So this is 2 lakhs of rupees was given, and the internal page 4 with Shivanand Mishra, it was a monthly rent of 400 rupees, payable according to the English calendar. If some amount is to be paid, Shivanand Mishra, he shall vacate the premises under his occupation and he will withdraw his case. They further stated that Mishra will vacate the room on the second floor, which to be later. Now, so the money comes in according to the plaint case as a loan, which I now say that this money I took it from him loan and I gave it to Mishra to vacate. Mishra in his compromise petition, which we filed together, the joint petition, there is no recording of that sort. Now, when Mishra now suddenly comes as the plaintiff's witness in this suit and produces this money receipt, a photocopy is produced. And the money receipt is generally from Mishra. It cannot be on my letterhead when he is receiving money. He is on my letterhead, a photocopy is produced and saying that this money was given to him as for is a consideration for giving up tenancy.
No, court says the Xerox copy of letter of delivery of possession.
No.
Letter of delivery of possession will be given by page 38 of the.
Page 38, yes. The page 38, the internal page 38 of the.
But the appeal court discusses this.
Yes, the appeal court discusses.
If it's a letter of delivery of possession,
that one.
then he gives possession to you.
No, yes, Mishra to me. That is Mishra to me. Page internal page 38. That is exhibit. That is exhibit 39.
Yes.
Exhibit 39. Exhibit 39 is that document. Is the Xerox copy letter of delivery of possession on the receipt of 2 lakhs by Mishra.
On receipt of 2 lakh is also there. Yes.
By Mishra. And then he says also a signature of Khaitan, tenancy, a similar letterhead. So that is also a photocopy produced. And I say this is also forged. And this is a ground in the first appellate decree. And there is no finding to that effect. So this is I say this is the perversity. And the second is there is no consideration. If largest pleasure will kindly look, because I say there is no section 25 of the Contract Act. Section 20.
So in the document, a consideration is mentioned.
It's 7,000 rupees or 6,800.
It's 2 lakhs of rupees security. The tenancy document. 7,000 rupees is the figure mentioned. But if not paid, nothing is paid. There is no not the plain case. There's any payment. They tried to make any payment. Now section 25 of the Contract Act. And a written statement about section 25.
Explanation 2.
Explanation 2 is sorry. Hey, now na. Copy to the explanation.
Section 25 heading is
Section 25 agreement without consideration void unless it is in writing and registered or is a promise to compensate for something done or is a promise to pay a debt barred by limitation. Now explanation 2, my lord. In an agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court, determining the question whether the consent of the promisor was given freely. Now, illustration G, which is part. A agrees to sell his horse worth 1,000 for rupees 10. A denies his consent to the agreement was given freely. The inadequacy of the consideration is a fact which the court should take into consideration whether or not A's consent was given freely.
This submission again recorded, no finding.
And there is no finding to the effect that the point that is raised, that the inadequacy of consideration, there is no finding. So, and there is no finding. And it is recorded in the order of the appellate, the order impugned order before this court, my lord. Internal page 10 of the order records this, but there is no finding.
And I have given evidence to show that the monthly rate is.
And there are evidence to show that the monthly rent will be 84,000 rupees, which I could not have given in 7, which is 1 rupee per square feet, which becomes 1 rupee per square feet for a commercial use, a banquet hall in Howrah. These things have been not at all dealt with by the court. And I have also given document to show that so far the renovation is concerned, we have paid them money. We have paid him, the plaintiff, money for renovation. So the plaintiff now converted this document, the blank document given to him. He introduces Shivanand also, that this money was paid to Shivanand. I have taken loan. And then he converted this document and made the tenancy document. So on these has been not dealt with by the court at all. So it's 2 lakhs of rupees for a 7,000 square feet, even if we go into, that's the inadequacy of consideration. But on these, but on these, I
said money is not received.
Yes, 107.25 and the compromise petition, he said that the money is nothing, no money.
That is at page 38.
But I say this appeal should be admitted.
The present challenge has been preferred against a judgment of affirmance whereby both the courts below decreed a suit for declaration of tenancy rights as well as delivery of possession in favor of the plaintiff stroke respondent. For sub next para, learned senior counsel appearing for the defendant stroke appellant argues that simultaneously, a suit was filed by the appellant challenging seeking cancellation of a purported tenancy document dated April 17, 1998, which was the plinth of the plaint case in the present litigation. Full stop. However, the said suit is still pending. Full stop. Next para, learned senior counsel argues that ample evidence was proved was produced by the defendant stroke appellant in the courts below, including air tickets, boarding passes, evidence of a hotel personnel in Delhi, to show that the defendant stroke appellant number 1 was in Delhi at the relevant point of time when the tenancy agreement was allegedly executed by him. Full stop. Next para, from the document in question, being exhibit 1 in the suit, it transpires then the same was allegedly executed on April 17, 1998. Full stop. However, from the boarding pass in the name of the defendant stroke appellant of the relevant date, it appears that the defendant could not have been in Calcutta at least before 9:30 a.m. on the said date. Whereas the plaint case is that the document was executed sometime between 9 and 9:30 a.m. in Howrah. Full stop. Next para, it is submitted that it would be impossible for the plaintiff to be present in Howrah at the relevant point of time, which belies the very existence of the document. For the next para, secondly, learned senior counsel places reliance on Section 25 of the Indian Contract Act 1872 to argue that no consideration passed between the parties, since there is no independent receipt of payment of such consideration and or any rent receipt produced on behalf of the plaintiff stroke respondent to substantiate the claim of tenancy. Full stop. Even otherwise, it is submitted that the purported rent fixed by the disputed document being exhibit 1, is grossly inadequate in view of the locality in which the tenancy was granted and the measurement of the premises, which is about 7,000 square feet. For next para, it is next argued on behalf of the appellant that the clear case of the defendant stroke appellants was that the plaintiff was put in possession of the premises the plaintiff was given the task of renovation of the premises in question, taking undue advantage of which the plaintiff claimed tenancy in respect thereof. Full stop. However, in the absence of any independent rent receipt and or a single paper to show the possession of the plaintiff in respect of the suit premises, both the courts below committed a patent perversity in declaring the tenancy rights of the plaintiff on the basis of exhibit 1. Full stop. Next para, learned senior counsel next further argues that the disputed document was purportedly executed in the letterhead of one, what is the name? Khaitan Paper Machines Limited. Full stop. However, the said concern was not the owner of the suit premises. Full stop. Next para, learned senior counsel takes the court through the findings arrived at by the courts below and argues that the appellate court erroneously relied on a photocopy of a purported letter of delivery of possession, allegedly on receipt of rupees 2 lakh within bracket exhibit 39 bracket closed by one Shivanand Mishra, comma, the admitted previous tenant of the suit property. However, comma, since Shivanand Mishra himself, comma, in his compromise petition signed along with the plaintiff, comma, admitted to have vacated the premises of his own, comma, there arose no question of payment of rupees 2 lakh by him. Furthermore, comma, it is argued that in the event a receipt was given for a payment made by the plaintiff to Shivanand Mishra and or delivery of possession by Shivanand Mishra to the plaintiff, comma, the receipt would have, the original of such receipt would not, under normal circumstances, comma, be in custody of the said Shivanand Mishra. Full stop. It is surprising, comma, learned senior counsel submits, comma, that such purported receipt, comma, only a photocopy of which was produced in the trial in the courts below, comma, was signed in the letterhead of the said Khaitan paper যেটা বললাম full stop. Next para. Learned senior counsel also places reliance on an order passed by the Honorable Supreme Court in a special leave petition in a special leave petition bearing SLP bracket civil number 11469 of 2025, comma, renumbered as civil appeal number 1101 of 2006, comma, which went up to the Honorable Apex Court in connection with an order obtained by the plaintiff stroke respondent for restoration of his purported possession in respect of the suit premises during pendency of the suit. Full stop. The Honorable Supreme Court, comma, while overturning such order, comma, made certain categorical observations casting serious doubt on the veracity of the plaintiff case. Full stop. Certain issues were flagged by the Honorable Supreme Court, comma, including the non-compliance of Section 107 of the Transfer of Property Act, as well as the consideration being inadequate, keeping in view the measurement of the suit premises. Full stop. Next para. The Honorable Supreme Court further observed that the question of admissibility in evidence and validity of Exhibit 1 had to be decided in the suit. Full stop. Next para. However, comma, such salient features of the case were given a total by the learned trial judge as well as the first appellate judge while deciding the suit against the appellant. Full stop. Thus, comma, it is argued that several questions of law are involved inasmuch as both the courts below erred in law in decreeing the suit. Full stop. Next para. We find from a perusal of the judgments of the courts below that both the courts appreciated the evidence elaborately and arrived at their own findings. Full stop. Next para. Insofar as the premise of the defense case regarding the defendant stroke appellant number 1 being in Delhi at the relevant point of time, comma, when Exhibit 1 was allegedly signed, comma, we find several discrepancies in such evidence having been pointed out by the courts. Full stop. For example, comma, the flight ticket of the defendant stroke appellant number 1 was of a different flight than the boarding pass produced in evidence. Full stop. Even as per the boarding pass, comma, the defendant number 1 was to arrive at Kolkata on April 17, 1998, comma, the day of execution of Exhibit 1, comma, at around 9:30 a.m. Full stop. Next para. Thus, comma, since the plaintiff's witnesses had stated that the document was signed around 9 to 9:30 a.m., comma, some amount of deviation is permissible and, comma, rather than belie the authenticity of the evidence, comma, all the same proves that the witness was being truthful. Full stop. there is always a margin of error if the facts are stated correctly by a witness. Full stop. Next para. More importantly, comma, a mutually destructive case in that regard was made out by the defendants themselves, inasmuch as a hotel personnel from Delhi produced documents and adduced evidence to the effect that the defendant number one had left the hotel in Delhi on the relevant date at around 2 p.m., whereas the boarding pass of the defendant number one produced by himself belied such case, comma, as per which he was to arrive at Kolkata at 9:30 a.m., which would be impossible. Full stop. Thus, comma, the defendants demolished their own case with regard to the defendant number one being in Delhi at the relevant point of time, comma, which was one of the cardinal plinths of the defense case vis-a-vis Exhibit 1. Full stop. The argument that Exhibit 1 was not signed by the plaintiffs is neither here nor there. Full stop. It is not mandatory in law, comma, in the event a tenancy is granted in the first person by the landlord, comma, for the signature of the tenant to be depicted in the same. Full stop. The Exhibit 1, Exhibit 1 indicates that the signature of defendant stroke appellant number 1 was there, comma, along with those of other witnesses. Full stop. The defendant stroke appellant number 1 does not dispute the signature but seeks to make out a case that such signature was obtained on the letterhead of a company where the defendant number 1 is also a functionary and later on converted to a tenancy agreement. Full stop. However, comma, since both the courts below elaborately discussed and appreciated the evidence in that regard, comma, a reappreciation of evidence and the factual aspects involved in the same in second appeal is not permissible. Full stop. Next para. Indeed, comma, under section 25 of the Contract Act, comma, the inadequacy of consideration may be germane. Full stop. However, comma, such relevance is in regard to the limited context of the consent of the promisor being freely given. Full stop. The case of the defendants is not that the consent of the defendant number 1 was obtained by force, but that of misrepresentation and fraud being allegedly practiced by the plaintiffs by obtaining the signature of the defendant number 1 on a blank paper and later on converting the same to a tenancy agreement. Hence, comma, the provisions of section 25 of the Contract Act are not squarely applicable. Full stop. Next para. Insofar as section 107 of the Transfer Property Act is concerned, comma, if a lease of immovable property is executed from year to year or for any term exceeding a year, comma, it can be made only by a registered agreement. Full stop. Other leases, comma, as per the said provision, comma, may be made either by a registered instrument or by oral agreement accompanied by delivery of possession. Full stop. Next para. It is settled law that even if a registered agreement is not produced, comma, it will be construed, comma, in the event the other parameters required in law to create a tenancy are satisfied, comma, if the possession is handed over along with an agreement between the parties being established, comma, which would then be treated to be a monthly tenancy. Full stop. Next para. In the present case, comma, Exhibit 1 itself evidences not only the payment of consideration but also the handing over of possession. Full stop. Since the said document itself has been believed by both the courts below upon consideration of the rebuttal evidence of the defendants, comma, there is no scope of invoking section non-compliance of section 107 of the Transfer Property Act in the circumstances of the present case. Full stop. The order of the Honorable Supreme Court, which has been relied on by the defendants' appellants, was in the context of an interlocutory proceeding, comma, where the respondent got an order of restoration of possession during pendency of the suit. Full stop. It is a trite law that orders passed, even if by the topmost court of the country, in the context of an interlocutory proceeding, are tentative in nature and cannot be binding at the final hearing of the suit itself, which is conducted by evidence trial on evidence. Full stop. That apart, there are comments galore in the said order itself, qualifying most of the observations made therein with the expression double inverted prima facie, double inverted clause, which itself indicates that the said observations of the Honorable Supreme Court were arrived at only for the purpose of deciding the restoration application and not meant to be conclusive insofar as the suit was concerned. Full stop. The only finding in the said order in respect of the suit, even otherwise, is that the genuineness of Exhibit 1, which was seriously disputed by the defendants, its admissibility in evidence, and validity were to be decided in the suit. Full stop. Next para. Both the courts extensively decided such issue upon adverting to the evidence on record, and upon such appreciation, came to a particular conclusion which is not altogether improbable. Full stop. Thus, the test of perversity is not met in the present case. Full stop. There cannot be a reappreciation of evidence by the Second Appellate Court if there is a concurrent finding of facts by both the first court and the first appellate court, even if in the opinion of the Second Appellate Court, a different view could be possible on the basis of the materials on record. Full stop. Looking at the matter from such perspective as well, we do not find any arguable substantial question of law having been raised in the present appeal. Full stop. In view of the above findings, SA 44 of 2026 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2026 stands disposed of as well. No orders to cause urgency. অন্য কালিতে হয়ে গেল যদি, ঠিক আছে, অন্য কালিতে হলো কিন্তু জাস্টিস ব্যানার্জিকে একবার বলে দিতে হবে।
My lord, I am for the appellant, my lord. I am seeking not today on the ground of Mr. Chakraborty is appearing in this matter.
Which Mr. Chakraborty?
Raghunath Chakraborty, my lord.
What happened to him?
My lord,
Very well. Not to record দিন, কিছু রেকর্ড করতে হবে। আচ্ছা, একটা অর্ডার on the prayer of the appellant, the matter is adjourned for the day. Appellants হবে। What is the defect? ও বলতে পারবো না। দেখি।
no,
Do you know the defect?
no, my
কত রকম কাজ থাকে না জজেদের, জজেদের কত রকম কাজ থাকে। Please go through the defects. Take a note. Apprise Mr. Chakraborty. Please go through the file later on when the officers get time and just take a note of the defects. ওনাকে একটু দেখিয়ে দেবেন কি ডিফেক্ট আছে যখন উনি দেখবে। Yes.
For the petitioner, I'm praying for not today, Your
Why?
Lordship. My senior, Mr. Arif Ahmed, is not well.
Same. On the prayer of the appellants, the matter is adjourned for the day.
number 20, 21.
20 and 21, my lord, I am for the appellant, my lord.
Yes, there is no caveat.
No, my lord. I've already moved that
Directed
matter.
to serve.
Yes, directed to
Section
serve.
5.
Section 5 in one matter. In item number 21, section 5 is there.
Don't move it today. You have a resolution.
But
Affidavit
there
of
was a
service filed
direction
today.
for paper publication, my lord. We have done the paper publication. But we had already served.
No,
that.
not decided today. We'll take it up.
Right.
Affidavit of service filed today be kept on record. It transpires therefrom that paper publication, substituted service has been effected by paper publication as per previous direction of the court. However, in order to give a last chance to the respondents to appear and contest the matter, the same is adjourned for the day. We are not mentioning that there is a resolution of that. That's not a valid ground.
Adjourned for the day. Very well. Very well. Deeply obliged.
My lord, I'm for the respondent, but I'm praying for not today.
Misappeal.
No, so there is a delay, my lord, 190 days, because one of the revisional application.
Affidavit of service filed today be kept on record. On the prayer of the respondent, the matter is adjourned for the day. Give your appearance, ma'am. Only your appearance, not your seniors.
23.
23, I'm for the appellant, my lord.
Yes. What is the defect? There's a defect.
I have not checked. I'm sorry, my lord. I have not checked.
There is no caveat.
No caveat.
Let's check up. Do you know the name of the presiding judge in the trial court?
Yes, it was.
So only you have to put that in the memo. We are granting you leave right now. Leave is granted to the learned advocate on record for the appellant to rectify the preamble of the memorandum of appeal by inserting the name of the learned presiding judge of the trial court, presiding judges of the trial court and the appellate court during the course of the day.
Yes.
Even if you lose, please do it. Yes. What is the matter?
My lord, I'm the defendant, my lord, is sued for eviction on the ground of default. My lord,
Only default?
Only default.
Both courts?
Both court. It's a admittedly plain case is a thika property, my lord. That is admitted in the plaint. My lord, kindly come to the plaint first. And at page 11 of my CAN application.
Sure. Did you raise this issue?
Yes, it was raised, but the learned court, not expressly, but it was stated that this
Not
learned
written
court is has jurisdiction under.
Achha, let us see the admission.
My lord, page, kindly come to page 13, my lord. 13. The plaintiff are the owner, landlord of the schedule mentioned property, Tarok Das, the predecessor of the present plaintiff, my lord, the original thika tenant. This is the plain case, my lord. Now kindly come to the eviction notice, which was exhibited at page 51, my lord.
Yes.
Second paragraph, my lord. You are a monthly ghor bharatia. Ghor bharatia is defined in thika tenant, my lord. Admittedly, I am a thika tenant. Now, my lord, the WS, I have stated the paragraph, page 20, my lord, in my WS. The paragraph I have dealt with, page 21, my lord. Para 9, that the contention made in clause 1 and 2, it will be para 1 and 2, of the said plaint are matter of record, need no reply. I admit that I am a thika tenant. That is one aspect.
Was an issue framed?
No issue framed, my lord. Another issue is, the quantum of the rent is ₹50 per month. My lord, now kindly come to the first court order, my lord, at page 62, my lord. Starts at 62. Relevant portion, issue number 8, my lord, at page 68. It was raised by the plaintiff in the eviction notice as well as the plaint that it will cover under TP Act. Issue number 8, my lord. The issue is to find out whether the defendant has violated the provision of M, O and P of section A.
But that is also ground under premises tenancy act.
the main issue is, my lord, the thika. That cannot be, and it was decided by the learned trial court, my lord, at page
No, but the bar under
21.
Section 21, read with section 8 probably or 5. That is in the 2000. This is a suit filed prior to that.
This was the suit
2014.
2014.
So how is it applicable?
My lord,
Taken
the
in section-
previous act.
Did the previous act contain any bar?
There
এই
is
তার
a-
তার তলাতে, হ্যাঁ, ওটাই। Joseph could be- Previous act did not contain the.
There was bar, my lord. 2001, it is 2014.
So prior suit, does it have retrospective effect? Let us
No,
just-
my lord, 2014. 2014.
Oh,
Act
2001, right?
2001.
This appeal will be heard on the following substantial question of law: whether the courts below acted, courts below substantially erred in law in decreeing the eviction suit against the defendant stroke appellant in view of the civil court lacking inherent jurisdiction to decide eviction suits between a bharatia and a thika tenant, in the teeth of the specific admission that the property is a thika property, both in the plaint filed by the respondent, both in the plaint and the eviction notice issued by the plaintiff stroke respondent. Yes, any interim or interim
Yes,
application?
my lord. There is a execution case, my lord. That case number is
There shall be stay of all further proceedings of title execution case number 40 of 2022 pending before the learned civil judge, Junior Division, 5th Court at Howrah, till disposal of Can 1 of 2026. First up, the appellant shall serve a copy of Can 1 of 2026, serve copies of Can 1 of 2026 on the respondents, indicating that the application shall be listed before the appropriate learned single judge after the timeline for filing of affidavits is over. Full stop. Affidavit in opposition shall be filed by the respondents within 3 weeks from date. Full stop. Reply thereto, if any, shall be filed within a week thereafter. Stop. Para. It is made clear that the question of imposition of occupation charges and, if so, the quantum thereof, is kept open for being decided at the final hearing of the stay application. The appellant shall file an affidavit of service at the time of hearing of Can 1 of 2026.
grateful.
I have to add, the trial court record shall be brought by special messenger at the cost of the appellant, to be deposited within a fortnight from date. First up, the appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Yes.
My appeal, my lord.
Yes. Yes.
Can 1 is my application for condonation of delay, and Can 2 is my lord for stay, or rather, my lord, injunction, really. I've been refused injunction by the trial court. My lord, may I just indicate what the suit is for? But my clients had engaged the defendant as a contractor in respect of various contracts awarded in
But
turn.
for that, you have to close the.
I'll just indicate what the suit is thereafter, my lord. That will help me in my condonation. That's my only prayer. My lord, so here, my lord, the defendant is my contractor. The defendant alleges to have certain dues payable by me to him. The defendant, instead of filing suit and instead of filing any
Contractor
appropriate
in what?
proceeding,
In a business or?
works contracts, my lord, for goods and services of sorts, my lord. I am, my lord, the principal contractor is my client under the government, my lord.
All
The Air Force as well as other governmental agencies award contracts to me because I'm Titagarh Rail Systems. I provide a lot of works contracts.
All right. Yes.
And he's my subcontractor, really, strictly speaking. Now, what the defendant does is, instead of filing suit or taking appropriate legal remedies, he starts writing to my contractors, number one, and also to a member of parliament who is at the head of the committee on petitions of parliament. Now, what that does to my client is, thereafter my clients face pressure from my employers to try and settle the disputes with the contractor. Now, his petitions, or if I may say representations to these authorities, are ex facie frivolous, and my client's contention before the trial court is, it has no basis whatsoever. Firstly, the claims that they make today are really in the nature of afterthought, because really the default that has been committed by the contractor is he's not deposited GST. When the GST authorities pull him up for non-payment of GST, he writes back to the GST authorities as well as these other authorities saying, no, the principal contractor has not paid my dues, therefore I am not in a position to pay GST. So it's in the nature of an afterthought. So I file a suit seeking declaration that there are no dues due and payable to the defendant, and also for an injunction restraining the defendant from making these defamatory, and I say defamatory and disparaging comments to the authorities, because my client is suffering irreparable prejudice. I'm being called upon, I'm being asked to show cause. In this context, I initially filed one injunction application in 2023. The suit is of 2023. In that injunction application, I'm unsuccessful of sorts, in the sense I pray for ad interim, refused. I come before
What sort of ad interim?
restraining him from making defamatory remarks similar to the earlier representations. I am not successful in getting ad interim relief. I come up before this honorable court. This honorable court reminds me back to the trial court for injunction area. I am refused an ad interim order also by the prior division bench. Now, in the meantime, before the disposal of that injunction application, I find that he's again started writing to the authorities. Therefore, I am compelled to take out a fresh injunction application, seeking again fresh injunctive relief, though that earlier injunction application is pending, but on a different cause of action. Because by that point, I had already obtained an auditor's report, which even the defendant is privy to, which shows there are no dues payable by my client to him. Rather, there's excess amounts that I've paid, which I am entitled to back. I put this before the trial court. The trial court rejects my injunction, rejects it finally after exchange of written objection. Second one. The first one, is not really disposed of. It's neither, because it's lost its force really. The second one is disposed of and rejected on 18 September 2025. From September 2025, I have 90 days to prefer the appeal. That expires sometime in December, right before the holidays, the winter break. My clients obtain a change of advocates in early January. I state that on oath in my Section 5 application. I obtain a change of advocates from January. I have explained the delay so far as I've been able to, from paragraph 3 to 6 of my Can 1, from January till date of filing, that is around May.
June.
Yes. June. I'm sorry, I've tried to explain it in paragraph 3 and 6. In the meantime, we had also tried to settle the matters amicably. That's not on record. I have not averred that also, because that's without prejudice to my client's rights. But that is the real cause, we have a substantial case on merits. If will kindly condone the delay, I'll show from the injunction application itself that I'm entitled to some interim protection. And
so, Banerjee, is any reconciliation possible in this matter?
No, my lord, I'll just, indicate why, my lord.
No, only that. Only on that.
No, yes, only on that, my lord. My lord, my client, my lord, wrote to Committee of Petitions of the Lok Sabha. Now, my lord, that body has been, my lord, framed for, my lord, all these issues, my lord. My lord, that body, my lord, held up meetings, called both the parties. My lord, number of sittings were held. In their office, it was also held, and mediation ultimately failed. So what I have done is, my lord, after this avenue has closed, my lord, I have taken out, my lord, a money suit in the commercial court of the Alipur.
That's fine, but Mr. Banerjee, if the dispute is resolved, then everything will be resolved.
My lord, mediation already, my lord, happened once here, and after that, already, my lord, in the money suit.
Then forget it.
Yes, my lord, in commercial suit.
Well, let him hear on the so Section 5. Let us see the grounds, Mr.
Yes,
then we'll come back to Mr. Banerjee on the Section 5.
But today, subject to correction, if they file the suit, today they shouldn't continue to write to the Committee of Petitions if they admit today that that avenue is closed.
I'll just indicate, my lord, that this was done, all prior efforts were taken, my lord, to write to the Committee of Petitions, my lord, prior to the suit. After the suit has been initiated from our side, my lord, this application is no more, my lord, enforced.
No, provided you do not carry on these defamatory remarks.
My lord, defamatory, my lord,
if you go on writing letters on the strength of your suit, now it will be.
Yes.
That yes, I substantiate my right because I filed a suit.
First of all, my lord, it's alleged defamatory. Second of all, my lord,
No, we are not saying defamatory.
Malad, if
I mean, definitive is said, but that's
if
tentative.
my learned friend, Malad, I'll just indicate, Malad, what? Malad, this is a committee.
It's defamatory, no doubt, but whether it's defamation in law, that has to be considered.
And secondly, Malad, one more thing, Malad. Malad, this is not a public domain. I'm not writing anything in public.
To a
in
parliamentary committee, Mr. Banerjee, parliamentary committee, everything, the records are in public domain.
Malad, by that, Malad, my humble submission, Malad, by that policy, Malad, anything that is Malad, brought to the court also, Malad, goes into the public domain, Malad, by that record, Malad. Public domain specifically, Malad.
No,
mean
court
newspaper,
proceedings are
social
specifically,
media.
there are certain judgments protecting court allegations. I mean, allegations made in litigations. Those do not tantamount to defamation. There are a line of judgments up to a point.
Up to a point.
Up to a
Malad,
point.
Same principle would apply for a legislative body as well.
So if my learned
Malad,
What about the section 5 first?
yes,
Let's go one by one.
76-day delay, Malad.
176 days,
But
Malad,
the-
paragraph 3 to 6, I've tried to explain from January till June, Malad. I've tried to explain. The conference is held. It took some time to draw the
Yes,
petition.
Mr. Banerjee, you are satisfied.
176. I'll not Malad oppose.
Third learned counsel for the, we are deciding this and then hearing the. Third learned counsel for the parties, full stop, on a perusal of the averments made in Can 1 of 2026, comma, this court is satisfied that sufficient cause for the delay has been made out, full stop, accordingly, Can 1 of 2026 is allowed, thereby condoning the delay and preferring FMET 175 of 2026. Now,
Malad,
yes,
may I
Mr.
submit
Ben.
one thing, Malad, may I submit one thing? Malad, kindly, Malad,
If you agree that you won't make any such,
Malad, kindly records my submission, Malad, that since the suit has already been filed,
without admitting anything.
without
Yes.
admitting anything,
Yes.
since the suit has already been filed, my client, for the time being, Malad, till the Malad, will not approach any other body for the time being in force.
That's good enough. That will serve my purpose as well.
Because there's no point
For
in
the time
approaching
being means, what does that exactly mean?
till the
Till your suit is
Till
dismissed.
disposal of the suit.
at least up to that, Malad. Malad, kindly, Malad, does not, Malad, takes it beyond that.
No, then till when? Now what? Ad interim has been refused or main
Final,
injunction?
final.
Then it has to be till disposal of the suit, this suit.
Malad, as well as Malad, I was meaning Malad, my suit. Malad, since Malad, I have Malad, there was a money claim from my side.
No, understood.
Malad, good but indifferent, Malad, there's a money claim. But I have filed a suit. Malad, I initially tried Malad other revenues. Now that that has failed, I have Malad finally taken out a suit within the period of limitation, Malad, to my Malad, humble
But that
son.
would be indeterminate. I mean, your suit maybe get dismissed for default tomorrow, suppose. Theoretically, it may. So that does not give them protection either way. Or we can, is there any scope of affidavits being filed here? Because
don't
they're bringing
believe
certain
so.
allegations.
This is after
All the
contest.
documents are annexed here.
All the documents are there.
So we can hear out this appeal itself along with the application. Until then, don't, we'll record your
Final.
submission that your client,
Yes.
because your client has filed a.
Yes.
So we'll keep it in the monthly list of September it will be, because August is difficult. The present appeal has been preferred against the refusal of injunction to the plaintiff stroke appellant. Full stop. The plaintiff stroke appellant, comma, alleging defamatory communications being made by the defendant stroke respondent to various bodies, comma, including parliamentary authorities, comma, has filed the suit. Full stop. By the impugned order, comma, a second injunction application, comma, on the premise of subsequent and continuing cause of action, comma, has been refused. Full stop. Next para, the premise of the defamatory allegations was the alleged non-payment of GST in respect of transactions between the appellant and the respondent, comma, the latter being a subcontractor of the former, comma, by the appellant, comma, which the appellant denies. Full stop. Next para, learned counsel for the respondent, comma, during arguments, comma, submits on instruction that in the meantime, comma, a regular money suit for recovery of such GST amount has been filed by the defendant stroke respondent, and, comma, as such, comma, there is no imminent necessity of further writing to any authority on the part of the respondent, at least till disposal of the respondent's money suit. Full stop. Next para, in view of such submission made on behalf of the respondent, comma, no interim order is required to be passed at present. Full stop. Next para, can 2 of 22, in view of the arguable questions involved, comma, the appeal is admitted to be heard on the grounds taken in the memorandum thereof. Full stop, the appeal shall be listed for hearing along with the connected application bearing can 2 of 2026 in the monthly list of September 2026. Full stop. Any other paper is required?
The Lordship, my lord, kindly gives me an exception, my lord, to file an affidavit, my lord. Otherwise, my lord,
So very well.
something, my lord, comes up.
Affidavit in opposition, comma, if any, shall be filed to can 2 of 2026 by the respondent within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Then prepare informal paperwork, Mr. Mukhopadhyay, annexing these papers, and if anything is annexed by them to the opposition.
We'll do that.
And you reply.
Kindly, my lord, accept 3 weeks, my lord, because I'm yet to.
Acha, very well. Oda 2 week, fortnight na kore 3 weeks, 1 week. Or the appellant shall prepare informal paper books incorporating all the relevant documents and pleadings without comparing with the records. Full stop. In view of the short compass of the appeal, comma, the trial court records need not be called for. Full stop. In view of the appearance of the respondent, comma, the appeal be treated to be ready as regards service.
My lord will kindly grant me some protection. My lord has said no in view of their submissions, but my lord will kindly at least know the expectation of court that they won't be writing to any other authority. My lord, today only their submission. My lord, my client.
My lord, that is undertaking.
No, my lord,
liberty is given to the appellant to renew their prayer for ad interim injunction on the basis of can 2 of 2026. In the meantime, comma, in the event the respondent does not adhere to his undertaking and makes further communications with regard to the appellant.
My lord, there was a defect, my lord, which I had pointed out on the last occasion. My lord, the name of the appellant had changed during the course of the suit. My lord, the trial court, my lord, the amendment was already carried out, but in the certified copy,
on the prayer of learned counsel for the appellant, comma, leave is granted to the learned advocate and court for the appellant to carry out the necessary rectification in the cause title.
My lord, cause title is correct. Well, the certified copy, the department had noted a defect because the certified copy shows the name of the plaintiff which as it was prior. That is the difficulty. Cause title is as per the amended plaint.
Previously, known as.
আচ্ছা, প্রথম লাইনে একটা অন্য জিনিস করে দাও। Learned counsel for the appellant submits at the outset that the name of the plaintiff stroke appellant underwent a change during pendency of the litigation, comma, pursuant to which appropriate amendments were carried out in the trial court, comma, as correctly reflected in the cause title of the certified copy of the impugned order. Sorry, as correctly reflected in the cause title of the present appeal.
Yes.
Full stop. However, comma, such corrected position is not reflected in the covered page of the certified copy of the impugned order. Full stop. Let such defect be deemed to since such defect is irrelevant for the adjudication of the appeal, comma, let the same not be the same shall not be a deterrent in the appeal being taken on board and decided on merits. Send করলে ট্রায়াল কোর্টে প্রসিড করতে হবে। মেনশন করতে হবে বিষয়টি আবশ্যক।
There is a delay of 38 days in filing the appeal.
This is happening for the first time?
Yes, Your Lordship.
Then ma'am, please serve a copy on the other side and come
Yes.
back. Yes.
It will be fixed up tomorrow, Your Lordship.
No, how can you serve so soon? You have to serve and file an affidavit of service.
Okay, Your
served by registered post with AD. So they're residing in Calcutta only. So
yeah, bang opposite to my office.
Well, the appellants shall serve copies of Can 1 of 2026 as well as a memorandum of the appeal on the respondents, indicating that the application shall next be listed on. You can serve within a fortnight.
I can serve tomorrow itself morning. Yeah, today evening.
We'll keep it after 2 weeks. You serve by registered post also.
Yes, Your Lordship, but matter is fixed up before city court on 18th of this month, July.
No, you cite this,
For the city court? That
yes,
matter-
you
okay.
cite the pendency of this and this, a copy of this order.
Yes, Your
Uh,
Lordship.
list, কি বললাম? Indicating
I'm
that the matter
sorry.
shall next be listed under the same heading on July 27, 2026, when an affidavit of service to that effect shall be filed by the appellants. If they appear, then if we allow the condonation, then we'll also may here take up the appeal for hearing it.
I'm deeply obliged, Your
Thank you.
Lordship.
Yes. My appeal, my lord, appeal from an order by which injunction was refused in a probate proceedings.
No caveat.
No caveat. My lord, even we moved ex parte before the Lord trial court.
So why refused?
My lord, refused, my lord, relying on section 213 of the Succession Act. My lord, I'll tell you, lordship, what happened. My lord, I am the elder son of the deceased. I am the executor and the beneficiary, sole beneficiary of the will. Now, in the injunction application, we are only.
You are a co-executor.
No, my lord, sole executor. Sole executor, absolute beneficiary. And in the will, the younger son was not given anything. Now, my lord, the will records that there is an earlier will of 2003, which is a registered one. Now, the registered will, the earlier registered will has been revoked by the latter unregistered will. The latter will is handwritten, it's a holograph will, and it was also typed at the instruction of the testator.
Holograph and type together, how can it go together?
But it was a holograph will, and thereafter, on the instruction of the testator also signed on the typed copy of the will.
Then it cannot be a holograph will.
But they both are. We have annexed.
Does the typewriter executed the will?
No, the typewriter did not execute the will. There was a handwritten will by the testator.
No, the typewriter, the machine. Otherwise, it cannot be a holograph.
Yes, that's right. But so we annexed both the wills with the application for grant. And
no, you sought a probate of which? You cannot seek probate of both the wills together.
No, well, we applied for probate of the typed copy because the typed copy has the attestation.
Why was it refused?
Well, refused, well, relying on that the court noted that there is an earlier registered will which gave everything to the younger son, and since under section 213, no one can stake any right unless a probate has been granted in respect of a will. So there is no apprehension at all. 213 has been omitted, but that has not been taken note of by the trial court.
The present challenges, yes.
But may I also, in all fairness, in the application for injunction, we did not pray for appointment of an administrative pendentiality. Lordship would be aware,
No, what did you seek in the injunction application?
We prayed for injunction restraining the respondent, the younger son, not to create any third-party rights in respect of one property which is lying vacant, which is under lock and key, and the younger son has his office in the same building.
So why are you submitting this in all fairness? Because corporeal rights are not.
No, well, because there are certain judgments which say that without applying for administrative pendentiality, the probate court cannot pass an order.
We'll think about those judgments when they appear. Yes, what else?
There is only also one ground that the court takes note of, that there is no affidavit from the attesting witness of the will, but the declaration by the attesting witness is annexed with the application for grant of probate. The court also does not take note of that.
The present challenge has been preferred against the refusal of ad interim injunction in a probate proceeding instituted by the present appellant, who is both the executor and the beneficiary of the said will. First of next para, by the said will, a previous registered will executed by the self-same testator was revoked. First of next para, the apparent premise of such refusal is that in view of section 213 of the Indian Succession Act, no right as executor or legatee can be established until probate of the will is granted. First of next para, however, prima facie such ground appears to be specious, SPE, inasmuch as in a probate proceeding, in terms of section 211, read with section 213 of the Indian Succession Act, it is the executor who has to represent the estate of the deceased testator, and in aid of the final relief to be granted, that is probate, interim protection may very well be sought with regard to the subject matter of the will. Full stop. Hence, an arguable case has been made out for hearing the appeal on merits. Full stop. Accordingly, FMAT 226 of 2026 is admitted, to be heard on the above questions and the other grounds taken in the memorandum of appeal. Full stop. The respondents and their men and agents and/or their men and agents shall remain both respondents.
No, respondent number one.
The respondent one and/or his men and agents shall remain restrained by an order of injunction from dealing with and/or creating any third-party interest and/or changing the nature and character in respect of the subject matter of the will.
That only two immovable properties were there. Only we are only concerned with one immovable property. This is which is set out in the prayers.
Acha, in respect of the immovable property, which is the subject matter of the will, comma, as enumerated in the prayer portion of the present application till disposal of can 1 of 2026. Acha, order এর মধ্যে ঢুকিয়ে দাও। As enumerated না করে, being within double inverted flat number, double inverted, no, being flat number 1 capital A, comma, double inverted Sutanuti Abason, double inverted close, comma, block A, comma, first floor, comma, 10D, comma, Kashi Mitro Ghat Street, comma, police station Shampukur, Kolkata 7,03,000. And what else? Only that.
Nothing. That is.
Till disposal of can 1 of 2026. Full stop. The appellant shall serve. Who is pro forma respondent?
The pro forma is the younger, the daughter of the deceased. Well, she has given consent.
She has given a no objection.
She has not given a no objection yet, but we don't have any allegation against her. So for the time,
serve a copy of can 1 of 2026 as well as the memorandum of the appeal on respondent number 1, indicating that the application shall be listed for hearing on July 27, 2026, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Service on the pro forma respondent number 2 is dispensed with for the time being in view of no relief having been sought against her. An affidavit of service বললাম কি? বলেছি. An affidavit of service shall be filed on the returnable date. Yes. Great. Next.
I appear on behalf of the respondent husband.
You're obviously for the appellant wife.
Milord, last time, Milord, you directed to file supplementary evidence.
Very good. Supplementary evidence. This is section 5.
Yes, Milord. No, not section 5.
We directed you to file.
The petition was not properly drafted, so there was no evidence for from the lower court and all.
What's that? Have you given a copy to them?
Yes, Milord, I'm giving.
You have given only one copy. There are two judges here.
Milord, I have another copy.
Give that. You're keeping it.
Sorry, Milord.
No, it's fine. Since you have given a copy to Mr. Chaturvedi right now, so he requires some time must be to, or we do.
Can you take it up? No difficult.
We'll take it up now. Very well. Yes. What is the matter? You have challenged what?
Milord, I request some time, Milord. Milord, because this is a transfer bill. I prepared the draft, but I am not prepared. I thought you would be asking for time.
When?
Milord, any day you choose.
So since you are so candid, you are entitled to time. When should next Monday then, or
Yes,
tomorrow? If you want tomorrow, we will keep.
Tomorrow, no problem. I have no problem.
Tomorrow then we are keeping. Mr. Chaturvedi. Very well. Leave is granted. Supplementary affidavits filed today be kept on record. Filed today by the appellant be kept on record. A copy thereof is handed over here and now to learned senior counsel appearing for the respondent. Full stop. Next para on the prayer of the appellant. The matter is adjourned for the day. Just come back tomorrow.
Milord, she begged to appear for the petitioner, Milord.
Yes.
Is the plaintiff in the suit, Milord.
Yes.
Now,
This
she
is
my
against
prayer
what?
for
Injunction?
injunction has been rejected, Milord, on contest, although I was given the ad interim.
You filed a suit for declaration of your title.
No,
anything?
title, no, it's a suit for specific performance of contract. Milord, readiness, willingness shown by me.
Why you refused?
No prima facie case made out by the plaintiff.
Why? Did not
Well, I don't know, possession was handed over to me in the year 2018. I was in possession.
No written agreement.
Agreement is there, it was unsigned.
Unsigned by anybody?
No, signed by us, yes, but not by the person who is willing to sell the property.
Then
There is a reason, there is a reason. But he had handed over the property to me in the year 2018.
on the assurance that I will give you, I will execute the sale deed
No,
afterwards.
Mr. Galip, sale deed can be executed later, but the agreement has to be signed. Otherwise, written agreement cannot be relied on.
No,
I agree to something, I don't sign it, that's not an agreement.
but enforceable.
What prevents you from manufacturing it? You get it typed and file it in court. I have to sign it at least.
No, my lord, lordship, it is not signed by the other side, but my lord, the position has to be, my lord, protected, my lord.
If it's not signed by the other side, it's not an agreement at all. You cannot agree with yourself.
No, no, but he has given me the hand.
We expected a better case, Mr. Galip, in your maiden appearance after that the panel thing.
Lordship.
So that we could give some relief to you. But
No, kindly cease, my lord. I think, my lord, I do have some case in this matter, lordship.
What
Kindly
case?
appreciate, my lord.
The proposed vendor does not sign the agreement.
No,
it's an
yes, it is
agreement.
unsigned, my lord. The reason is why, my lord, is stated in the averment, my lord. Kindly have a look at the plaint, my lord. My lord, there are 3 applications. One is section 5. I don't know why my learned junior has preferred test. I think section 5 is not needed. But abundant caution, he writes. Can 1 is section 5.
Abundant or abundant?
Abundant.
When was let us see.
No, it is, my lord, kindly sees para 3. Can 1 is section 5, my lord.
No, the order was passed when. Let us see, check up whether.
Yes, order was passed on 9th, my lord.
City Civil Code.
9th February, yes, it is civil code 30 days.
Yes, 9th February.
So 9th February, now, my lord, may I respectfully invite your lordship, my lord,
When you have applied.
application was on
Yes.
10th February. Delivery was 12th March.
No, it's perfectly within time.
Yes, within time. Well,
So we are dismissing this as not pressed.
as not
Redundant.
pressed, my lord.
You have filed can 2 for injunction and can 3 for
Can
stay.
2 for injunction and can 3 for can 2 is injunction
Stay of
application.
operation of non-grant of injunction. Can 1 of 2026 is an application for condonation of delay. Full stop. However, comma, it is rightly submitted by learned counsel for the appellant that the same has been filed erroneously, as there is no delay in preferring the appeal. Full stop. We find from the relevant dates as enumerated in the certified copy of the impugned order that learned counsel for the appellant is justified in submitting that the appeal has been filed in time. Full stop. Accordingly, can 1 of 2026 is dismissed as redundant, as infructuous, as redundant without an order to cost. But what about the appeal, Mr. Galip? There is nothing.
My lord, he has received by consideration money also 1 CR.
Receipt?
I'm showing the payment also.
Receipt you have filed in the.
Yes, I have shown this it was paid online.
So then it's an oral agreement.
Yes, page 36.
Then it should be an oral agreement.
36 illegible copy to down. 36. This 1 CR was given to him. He's Ashish.
Some documents are such that giving illegible copies to the
No,
court
lordship,
is
lordship,
easier.
lordship, my lord, I tender man.
Legible copies given, then the court may go otherwise.
আমি বলেছিলাম 36 legible copy টা দাও lordship in your lordship's
bank statements look the same to me even if it's a legible copy.
Legible.
Equally complicated even if legible. So it's a bank statement, that much we can find out.
Yes. Now, my lord, kindly sees.
No, but legible copy is required. Yes, you're right. Because the names, what is the name of the respondent?
Ashish.
Oshim.
No, Oshim is not. Ashish is the person who was supposed to be my vendor.
Who is Oshim then?
Oshim is my husband. Plaintiff's husband. It's a fight between Daur and Bodhi.
So then why have you made your husband a party?
No, they are all parties to the suit, my lord, because there was a my lord, business partnership.
No, then in the computer form, you have the first name is Oshim. It should be Ashish. Oshim
No, it
is
is
a
Ashish.
performer. The computer form, the first name is Oshim.
Oh, but in the cost settlement, kindly see it is Ashish
Yes,
only.
everywhere in the computer form, Oshim is the first.
Oh, well, in the cost settlement.
Apparently, Oshim is conducting on your behalf also.
No, Ashish is Miller in the cost. Ashish is Miller. That is lordship. That is different. So Miller, my
So how
quarrel
can you
is
rely on a written agreement simultaneously with an oral agreement? Let us see the plaint case. Let us first.
Miller
come.
plaint case is Miller. Kindly see Miller at page 15 is the plaint lordship. May I, my lord, respectfully invite your lordships, my lord. Kindly seize the plaint.
No, you are saying that it's a It's a memorandum of understanding between the parties.
Memorandum of understanding, and Miller kindly sees page 19, para 6. Page 19, para 6, Milord, the plaintiff paid a sum rupees 1 crore to the defendant through banker's check. He has accepted it. Now, Milord, on para 7, defendant simultaneously also delivered possession of the room 2B. This is a suit property. 2B, second floor, 191 Mahatma Gandhi Road. In the year 2018, this is what he has done. And Milord, reason for non-signing, Milord, may I respectfully invite your Lordship, Milord, to page 22, Milord, paragraph 12. The aforesaid memorandum of standing was made in between parties on 20th December. Plaintiff since then holding possession of the said shop room with the hope that since it is an undertaking and a commitment being made by near relative, it will not. It's a Milord, sister-in-law and brother-in-law, Bodhi and Daur. Holding possession of the said shop room with the hope that since it is an undertaking or commitment being made by near relation, it will not dishonor, and on all occasions defendant was agreed to execute the sale deed. Then Milord, at paragraph 14, Milord, I approach him April 2019. He made me even pay, Milord, the stamp duty. Stamp duty, Milord, I have paid the entire, Milord, my stamp duty payment. May I respect that your Lordship, Milord, to page, Milord, 49, Milord. This is the stamp duty to the tune of rupees, Milord, 6 lakh odd. Kindly see page 49. Firstly, Milord, may I show your Lordship page 51? There is a query. Query, kindly see page 51. Query date, Milord, 4th April 2019. He made me do that also. Stamp duty payable, 5,76,000. Lordship gets it. Lordship, Milord, kindly right hand side, registration fee 96,000. Kindly see next page 52. Ashish is the vendor. Buyer is Rinku. Plenty, 52. Now kindly see my payment, Milord. My payment is this page 50, 50, Milord. 50 is my payment, 6,72,000. Page 50. The payment I made, Milord, on Milord, 8th April, Milord, 2019, Milord. Now, Milord, juxtapose, may I again, Milord, respectfully invite your Lordship to come back to me the plaint, Milord. Kindly see the plaint thereafter, Milord. Plaint, Milord, at page 23, Milord. Page 23, Milord, may I, Milord, respectfully invite your Lordship?
Made the payment to whom?
To the government for
what?
registration fee and stamp duty for getting the deed registered.
That may be a unilateral act on your part.
As because, Milord, he has already accepted
You did
payment.
not make any payment to him.
No, he has already made. No, once here he has taken the consideration money at page 36. Ashish.
That is the bank statement.
Lordship, online payment was made. He has accepted it also in the Milord in his written objection.
How the trial could proceed.
And Milord, may I respectfully invite your Lordship next, Milord, to paragraph, Milord, 15. Page 23 of the plaint. Kindly see para 15, what I state, Milord.
Yes.
Plaintiff believed upon such commitment and did not initiate any proceeding for the reason since the defendant committed to perform his part of the contract after the situation normalized. Because in between, we not kindly visualize after 2019, COVID sets in. So everything was, Milord, in the Milord back foot. And thereafter again, when the normalcy returned, then again I started pursuing. Now para 15, Milord, kindly sees. That is why I say it may be mentioned that through the memorandum of understanding was made.
Difficulty, Mr. Galib, is if you relied on a nodal agreement, we could have understood. That could be substantiated by this. But you are relying on that memorandum of understanding itself being the contract. But that contract is invalid because there is a signature of the contracting party against whom you want to enforce it. Your case could be better if you had relied on an oral agreement. You never mentioned the expression oral agreement anywhere. Could be an oral agreement independently, and that was put in writing by you of a memorandum of understanding, which you are supposed to. There could be a better story.
Milord, that
if you said you had an oral agreement pursuant to which payments were made, etc., and that was put down to writing. After being reduced to writing, the agreement was that both of you would sign that. He refused to sign and all. Refused to sign it. Where do you mention the agreement? The mention of the agreement is entirely regarding this memorandum of understanding. What is the independent agreement that it was orally agreed between you? You place your entire reliance on the memorandum of understanding which is not signed by him. Just see the plain case. There is no independent oral agreement between you. Dispute resolved, para 2, on the basis of memorandum of understanding between the partners. And then you go on to say
why he did not sign it.
Yes.
In para 15, my lord, I have given the reason, my lord, as to why he has not signed it.
If he did not sign, there was no consensus at item.
No, my
He
lord.
unilaterally made payments to him.
My lord, may I
There is nothing from his end. Nothing.
No, but my lord, he has received the consideration money of 1 CR, my lord.
He made an online transfer.
I'm showing it. Then, my lord, he made me, my lord, pay the, my lord.
He appeared in the trial court.
He appeared upon contested hearing my injunction
in his
petition.
written objection. What was his explanation regarding this?
His
payment?
explanation with position, he says regarding position, he says, I never handed it over. They got this wall demolished and internal.
Forcibly.
Yes, but in his.
What about the money?
Money, he says, the story kindly sees the, my lord, what he says. He says, my lord, that was supposed to be paid in terms of the business partnership business, not in terms of the consideration. But that was altogether different thing. He says that I was supposed to be paid 2 CR on account of our family partnership business. But that family partnership business is altogether different thing. It is in no way, Miller, related to this particular transaction for.
That is what you are saying, but we merely see a transfer of an amount of 2 crores.
No, I transferred only 1 CR. That is the consideration. He says I received 1 crore, 21 lakh, 21 more. He says kindly sees the, my lord, impugn order, my lord. His entire contention, my lord, in the written objection has been recorded by the learned judge, lordship. My lord, may I respectfully invite your lordship, my lord, to the impugn order, my lord. Kindly sees, my lord, the memo, my lord, or my lord, the stay application.
Everything is unilateral on your part. You transfer an amount of money, you pay to the registering authority. Nothing we find precious, nothing from his end.
My lord, may I place his, my lord, part of his story, his part of the story, my lord. Kindly sees, my lord. What does he say regarding the payment of 1 CR? Page, my lord, 110 of Can 3 I am placing.
Are you placing from the impugn order itself?
Yes, I am placing, my lord.
Refer to the internal pages, we are seeing the memo.
Internal page 6, my lord.
6, we are there, yes.
Kindly sees, my lord, first paragraph from the top. It is stated that in accordance with the oral agreement, this is his contention. Dated 26 November 2018, the deed of admission cum retirement of partnership was jointly signed and executed by the plaintiff and defendant number 124 on 31st December 2018. By dint of which the defendant number 1 exited the said partnership firm and the defendant number 3 joined the said partnership firm. It is stated in the terms of the oral agreement dated 26 November, the plaintiff first issued a check of 1 CR and then another check of 21 lakh in favor of defendant number 1.
The bank statement shows payment of a check or online transfer.
It's online transfer. Check.
So he admits that check.
He admits.
But he gives a different.
But he gives a different story of admission cum retirement deed. That is altogether a different story. I can.
Did he produce that admission cum retirement deed?
My lord, he has produced and we have brought it also. Their lordship will not find any whisper regarding all these things.
Payment of money?
No, here, my lord, there was a partnership family business, and here it is stated that
in that retirement,
who is going to retire? No, in this deed, there is no mention of any amount. So he is, my lord, drawing a relation with these. Between this and this deed of retirement and admission, we does not have any connection.
Just give us a copy. We'll keep it on record. One of the copies.
Lordship. This is deed retirement cum admission, which is referring to, my lord. Kindly see, there is no reference. And regarding staircase, this construction by me, possession was not given by him voluntarily. That is also out and out with a false, my lord, statement, my lord, because from his sell deed, by dint of which he had purchased his shop, which he is supposed to transfer to me now, from his sell deed, my lord, will find there was already an existing staircase. That was not constructed by me at all. This is admission come retirement.
Someone is admitted, someone retires.
Yes, so my son is going to be admitted, and retirement will be of Ashish and his wife from family business. No whisper regarding any payment. Yes, final payment whisper was there in the balance sheet, where, my lord, balance sheet says the payment will be only of 52 lakh and odd, not this 1 CR or 2 CR, what the story which he's trying to make out in the suit, my lord. And regarding, my lord, possession part, which he said, kindly sees, my lord, regarding possession part, what did he say before the learned judge? Kindly sees.
Yes, demolished a portion and entered.
Demolished a portion, he says. Kindly, my lord, may I respectfully, my lord, hand over the sale deed which he had executed for purchasing this shop in the year, my lord, 2018, my lord, kindly sees. There were.
No, but this was not a part of the trial court records.
No, he had placed it.
No, this sale deed was not referred to him.
He has referred, my lord, kindly sees internal page 6, my lord, paragraph, my lord, the one which I have read. Next, my lord, the paragraph starts with, it is stated that after purchase of said shop, room number 2B at 191 MG Road, the defendant one stored substantial quantity of stocks and other important documents pertaining to his present business, including.
Yes, fine, but did they produce this document? That is not reflected.
My lord, I am not in a position, but they have specifically mentioned.
Objection must have been annexed. Please check from there whether they have annexed this.
No, they have not, lordship. I don't find.
Then we cannot look into it. Anyway, from these, their stand is clear from this.
Lordship. My lord, let me check from his objection to the, my lord, injunction application, my lord. Lordship, kindly, my lord, kindly give me some time, my lord.
In your injunction application, you have said memorandum of understanding was signed by the plaintiff petitioner, her husband and Asim Bhomik.
But not by, I have said that it is not by him. I am very candid, my lord. My lord, this deed of admission he had annexed in the written objection. Lordship will find from page 83, my lord, of Can 3.
What?
This admission deed he had, my lord.
Sir.
Annexed to his written objection.
That it's referred to in the order also.
Yes, my lord. And this sale deed, my lord, referred to in order.
Understand your plaint case, actually. I mean, you say that there's a written agreement between you that is not signed by him.
My lord, fully admitting that position, my lord, but my lord, kindly sees the successive, my lord, conduct, my lord. He receives the payment, he accepts it. Yes,
I have not stated that it is not your plaint case that oral agreement was reduced into writing. And
no, it is nowhere. It is nowhere there.
Difficulty.
But my lord, he has received once here that he admits, my lord. But for some other reason, he says, my lord. But my lord, I could clearly, my lord, show you, lordship, that was not for other reason. That is a reason only for, my lord, selling this particular, my lord, suit property, my lord. Once here.
What sort of injunction he was seeking?
And possession also he admitted, my lord. But he says some other story, my lord. So receiving of consideration admitted.
What is the injunction he sought? In terms
my lord,
of
injunction, my lord, not to transfer, my lord, alienation, my lord. My lord, page 70, my lord.
Disturbing peaceful possession also you was.
Peaceful possession, my lord, kindly protect my possession, my lord. Page 70 is my lord, prayer, my lord. Page 70 of Can 3. And my lord, third party interest not to be, my lord.
The present challenge has been preferred against an order whereby the temporary injunction application of the plaintiff / appellant was dismissed. So next para, the appeal arises out of a suit for specific performance of a memorandum of understanding purportedly entered into between the plaintiff / appellant and the between the parties. For the next para, according to the plaint case, the parties agreed to an arrangement between themselves. According to the plaint case, the parties, who are partners, who are were partners in a partnership firm, entered into an arrangement between themselves, which was reduced to writing by way of a memorandum of understanding, initially, due to the familial relationship between the parties, no signature of the defendant / respondent 1 was insisted upon on the part of the plaintiff / appellant. However, pursuant to the agreement between the parties, it is alleged that the plaintiff issued a check which was duly deposited, comma, as reflected in the bank statement of the your bank statement or there
It is there. No, you are paying. Oh no, it is mine.
of the plaintiff, comma, in favor of the defendant number 1. Full stop. That apart, comma, possession of the property was also handed over in favor of the plaintiff by the defendant number 1 pursuant to such agreement. Full stop. However, comma, the learned trial judge, comma, although initially granted ad interim injunction, comma, subsequently dismissed the injunction application on the ground that the memorandum of understanding was not signed by the defendant stroke respondent number 1. Full stop. Next para. Although fact remains that the memorandum of understanding was not signed by the defendant stroke respondent number 1, comma, which is also admitted in the plaint itself, comma, fact remains that the plaintiff produced prima facie documents to establish the payment of a sum of rupees 1 crore in favor of the defendant stroke respondent number 1, as well as the position being in favor of the plaintiff, full stop, insofar as the defendant stroke respondent number 1 is concerned, comma, the payment was sought to be explained away as a part of the understanding between the parties in terms of the admission and retirement deed entered into between the partners. Full stop. However, comma, from the said deed, comma, which was relied on by the defendant number 1 in the trial court, comma, we do not find any mention of any particular amount being paid. Full stop. Next para. Insofar as the position is concerned, comma, the defendant stroke respondent number 1 has alleged in his written objection to the injunction application in the trial court that such position was taken forcibly by the appellant and not handed over in pursuance of the agreement between the parties. Full stop. However, comma, the character of such position is required to be decided on trial upon evidence. Full stop. At this stage, comma, sufficient prima facie corroborative evidence has been furnished by the appellant to come to a preliminary finding that a case of an agreement between the parties and payment and possession in terms of the same having been handed over being made out. Full stop. Thus, comma, FMAT 99 of 2026 is as admitted, comma, to be heard on the above questions and on the other grounds taken in the memorandum of appeal. Full stop. Since from the pleadings in the applications filed before, since from the pleadings of Can 2 of 2026, comma, sufficient urgency and prima facie case have been made out, comma, the respondent number 1 and or his men and agents shall remain restrained by an order of injunction from selling, transferring, alienating and or encumbering and or creating any third party interest in respect of the subject property in any manner and or from disturbing the peaceful possession and enjoyment of the appellant in respect of the subject property during pendency of Can 2 of 2026. Full stop. Next para. The appellant shall serve a copy of Can 2 of 2026 on the defendant stroke respondent number 1, indicating that the application shall next be listed for hearing in the monthly list of August 2026, when an affidavit of service in that regard shall be filed by the appellant. Full stop. Next para. In view of no relief having been sought against the pro forma respondents, comma, service of notice on the said respondent, pro forma respondents is dispensed with for the present. Full stop. Affidavit in opposition, if any, shall be filed to Can 2 of 2026 within 3 weeks from date. Full stop. Reply, if any, shall be filed within a fortnight thereafter. Full stop. Acha, ota returnable monthly list of September. Fortnight thereafter. Full stop. Next para. Insofar as Can 3 of 2026 is concerned, comma, there is no scope of grant of stay of operation of an order dismissing an injunction application. Full stop. Accordingly, Can 3 of 2026 is disposed of without any order. Is disposed of without any costs. 3 disposed of, 1 disposed of, 2
Two remains.
remains pending, and that will suffice for it.
Lordship. Lordship, till till
Disposal of can 2 of 2026.
till disposal of can 2, the order will, the interim.
Injunction ta bolechi to
Till disposal of can 2.
Can 2.
Lordship. Grateful.
No, not dispose of can 2.
No, till disposal of can 2. Grateful to your lordships.
Defect technique. What is the defect?
Defect.
Relay. FMA number police. Not defect. আগে অ্যাডমিট না হলে এখন অ্যাডমিশন হওয়ার আগে এফএমএ নাম্বার, এটাই তো এফএমএ নাম্বার পড়েছে অ্যাডমিশন হওয়ার আগে করে যায়। এনিওয়েজ তা হচ্ছে
Grateful to.
29 lawsuit. I am appealing of the defendant number 1 appellant lawsuit.
Where are you groaning? Nothing in your case.
No. Lawsuit appeal against the injunction order. Temporary injunction.
Granted. Suit for
partition.
Why should
No.
it be granted?
Yes. Lawsuit admittedly play cause of action arose that my client started the construction of his land. I have filed a written statement as well as a written objection. Specifically stated that after getting sanction plan, I started the construction of my residential house, 660 square feet. Total land is 10 decibel. The fact of the case,
Total land is, sorry?
10 decibel. I have the plaintiff case that I am getting 1/4 share. If I am getting 1/4 share, within that share I constructed it. But
You're taking the best portion.
Actual case is that originally land belongs to Toroni Doloi, Rajendra Nath Doloi, and Horipodo Doloi. They transferred the said land in favor of Gaur Hori Jana in the year of 1967.
Are you disputing itself joint property?
Yes, I purchased when I purchased this property as a minor, repented my father. Thereafter, in the year of 1970, in the year of 1971, my father transferred another person to this land in his individual capacity, not in my capacity. Thereafter, they again transfer to my father on the basis of that plaintiff getting the partition, paying for partition, that their joint property. But when in the year of 1970, the sale deed.
You're admitting the appeal, Mr. Das, but we cannot stay the operation.
But in the meantime, losses any season construction.
No stay of
Lossy admittedly my written objection. Kindly see written objection. Construction already started. Lossy.
What was the stage of construction?
Lossy plinth roof level. Lossy up to roof level.
Ground floor.
Yes, ground floor. Lossy.
Keep the construction there. Yes. You are not
residential house. Lossy.
Maybe residential. You must be residing somewhere else.
No.
G plus. What is the plan?
That is under Awas Yojana. Only ground floor. Lossy paragraph my written objection paragraph 20. Lossy page 32. And also I annexed the plan also.
Awas Yojana is still there.
No, the Awas Yojana only 250 to 30 square.
All Yojanas have been recalled now.
But my construction more than 600. So necessary. Paragraph number 20. Lossy my written objection page 32. Lossy.
Paragraph number
20, page 38.
8, say that. Yes.
That while the defendant Manojan Janda used to exercise his right title interest was over the same, and the defendant had decided to construct his dwelling house over his purchased land, and for that reason the defendant had sanctioned the building plan for his construction from the authority concerned on 26/12/2023, and thereafter the defendant took permission from the local panchayat about his construction measuring 626.63 square feet. And thereafter, the plaintiff started construction of his dwelling house. The house is already constructed up to roof level, and wooden centering of the roof has also already.
How soon can you serve, Mr. Das? We are not granting expertise order. Stay.
Only
complete the construction, nothing will remain in the suit itself. At least in the injunction application. This is ad interim
No, injunction.
Temporary injunction. Nothing will remain in the appeal. It will be allowed before we hear them. Cannot do that. Motion can serve and come back. We are keeping it 2 weeks hence.
So now, any season, I am deciding only triple said lossy. They are lossy. But if admittedly, if I am the 1/4 share, then within this area
will
also.
be in a portion of your choice.
But my factually, as this case, the deed in my name and record of right in my name also. That was also reflected in the order. And also, like kindly see the impugned order, nothing was reflected.
No,
Nothing was.
We are admitting the appeal. You have made out a very good.
Lossy, kindly come to the impugned order, Lossy.
Yes.
Regarding construction, nothing was reflected. Regarding construction, nothing. Only last paragraph. The factual aspect was stated, Lossy. Keeping in mind all aspects, I find it just and proper to dispose the
So you have made a good ground, but we are admitting and directing it to appear after 2 weeks. You will take up the application upon hearing them. The present appeal has been preferred against an order granting temporary injunction in a suit for partition filed by the plaintiff stroke respondent numbers 1 to 4, 1 to 3. So next learned counsel for the defendant number 1 stroke appellant argues that the learned trial judge, while passing the impugned order, did not advert to the case made out by the appellant. First of the appellant, it is submitted, after obtaining duly a sanction plan on the strength of the purchase deed of the exclusive portion of property where the construction is being made, started such construction, which has been completed up to the roof level of the ground floor. First up, at this juncture, the plaintiffs filed the suit and obtained the injunction. First up, next para. Apart from disputing that the property is a joint property, in any event, the plaintiffs, in their suit, have admitted that the defendant number 1 stroke appellant has 1/4 share in the property. First up, the construction, it is submitted, is being made within such share of the appellant, even going by the plaintiff case. First up, thus, it is argued that the learned trial judge erred in law in dismissing the in granting injunction. So next para, a strong prima facie case has been made out by the appellant, in the light of the arguments advanced, as indicated above. First of next para, however, grant of stay at this juncture would tantamount to allowing the appeal without hearing the defendants, plaintiff stroke respondents. First up, accordingly, we desist from granting stay at this juncture. First up, next para. However, we intend to take up the appeal for hearing along with the application on the returnable date. First up, the appellant, accordingly, shall serve copies of the stay application and a copy of the memorandum of the appeal, along with a server copy of this order. Mr. Das, so that they know it's a hearing of the appeal. Server copy of this order on the plaintiff stroke respondent numbers 1 to 3 and file an affidavit of service on the returnable date. First up, the matter shall be listed under the same heading on July 27, 2026 with the understanding, same heading, order for
Yes, Lossy.
No, under the heading application on July 27, 2026 with the understanding that the appeal along with the application shall be taken up for disposal. First up, service of notice on the defendant number 2 is dispensed with since no reliefs have been sought against the said respondent. Arekta line add korin, in view of the short ambit of the appeal, the trial court records need not be called for.
Number 30.
Yes.
There is no caveat, my lord.
Defect.
Defect, I think, has been cured. It appeared in the logima.
Cured. The defective হিসেবে আসবে, হ্যাঁ। আপনি ডিফেক্টিভ যেটা রিমুভ হয়ে গেছে সেটা ডিফেক্টিভ হিসেবে লিস্টে দেবেন না।
Defendant is the appellant before your lordship. A suit is filed under the West Bengal Premises Tenancy Act, treating me as a tenant. After the suit is filed, an application is taken out for amendment to convert the cause of action into one under 2G. Although on the date of filing of the suit, the 2G ground was available to them. At the trial, the learned trial judge says that once you have converted it into a 2G suit, then it becomes a suit for eviction of a trespasser under the general law. You have not been able to prove your title, so the suit is dismissed. The first appellate court remands the entire suit on the basis of an application under Order 41, Rule 27, filed by the plaintiff seeking to disclose his documents of title without assigning any reason as to why the Order 41, Rule 27 application is being allowed. The documents of title were with the plaintiff. The trial court finding is that not only did he not bring on record any document of title, there is not even a pleading in the plaint, and I'll show your lordship the plaint, that he is the owner of the property. The trial court finds that he has not even been able to establish, file a document showing that there was any landlord-tenant relationship between him and his mother as he claims in the plaint. So now the question is, if the plaintiff chooses to amend his plaint and move from a suit under the West Bengal Premises Tenancy Act to a claim under general law, without putting in the necessary averment that I am the owner of the property, I have better title and therefore I seek your eviction, does not rely on the documents which are in his custody and possession, can Order 41, Rule 27 be invoked in those circumstances to remand the suit on an open remand?
Although the appeal has been preferred against an order of remand, since the arguments advanced by the defendant / appellant pertain to the merits of the matter as well, we choose to formulate the following substantial questions of law for the hearing of the appeal. First up, the appeal is admitted and shall be heard on the following substantial questions of law, Roman 1, whether, in view of the regards of Order 41, Rule 27 of the Code of Civil Procedure having not been satisfied by the plaintiff / respondent number, plaintiffs / respondents, the learned first appellate judge was justified in remanding the suit by allowing the application for production of additional evidence. Roman 2, whether the suit, being initially framed as one under Section 6 of the West Bengal Premises Tenancy Act 1997, and there being no pleading as to the title of the plaintiff / respondents, could subsequently be converted. Did you prefer any revision application against the amendment?
No.
Better, you get 105.
Yes.
Could be converted to one under Section 2 within bracket small g of the 1997 Act. These two grounds for the time.
Yes.
Any interim
stay of the proceedings in the trial court. Yes.
There shall be stay of all further proceedings in title
Ejectment suit number 18 of 2013.
Ejectment suit number
18 of 2013.
18 of 2013. Pending
the
before the learned civil judge, Junior Division, First Court at Shialda, District South 24 Parganas, after remand till disposal of Can 1 of 2026. First up, the appellant shall serve copies of Can 1 of 2026 on the respondents, indicating that but it remains a misappeal. So therefore, we'll hear the.
I am so sorry, my lord.
What happened?
There was a caveat I had solved. So sorry.
Mr.
I'm so sorry.
We
I
have a resolution. You should not.
Yes, I confused it with another matter. My lord. Kindly keep this for tomorrow. I'm so sorry.
Affidavit of service filed today, fullstop despite ekota kete daও kete বাঁধিয়ে একটা কপি মিসা বসের হাতে ধরিয়ে দাও. Affidavit of service filed today be kept on record. Despite service, none appears for the caveators to respondents, fullstop, as a last chance to the respondents to appear and contest the matter. The same is adjourned for the day. Come back tomorrow. Just remind us.
Yes.
Yes.
One, I am for the appellant, but I'll pay for blood 1 day's accommodation. I couldn't prepare myself.
Not today. Is there any caveat?
Yes, there is a caveat. There is
Additional ground. Affidavit of service filed today be kept on record. None appears for the. Who is appearing? You are appearing.
Yes, I am.
So then you're ground.
No, I'm supporting Mr. Mukherjee, my lord, in this matter, because I am for the defendant number 3.
None appears for the plaintiff's caveators at the time of call. Full stop. Let the matter stand adjourned for the day.
Lots.
Yes.
But
Yes.
application.
What is the matter?
There are 4 applications pending before your lordship, my lord. First is, my lord,
Is
response.
there appearing for the first time, Mr. Arifin?
But what happened, my lord? The appeal was admitted, my lord. Now thereafter, my lord, there was a direction by the registrar, my lord, to deposit requisite, my lord. That requisite was not deposited, my lord. For that, my lord, it was dismissed by your lordship, my lord. So, my lord, I have filed an application for restoration of this appeal. Thereafter,
Did the respondent appear at any point of time?
Yes. There was a direct, but they filed Vogalatama. It's on record, my lord.
Then, Mr. Arifin, don't move it today. Come back tomorrow. Today you have a resolution. Give a notice to them.
Notice, we tried to serve to the advocate. They said that we have no instruction now. So, my lord, we serve all this application directly to the parties.
Very well. Learned counsel for the appellant submits that despite attempt to serve,
they refused.
Notice of the appeal. Attempts to serve copies of the applications on the learned advocate who appeared for the respondents in the appeal, comma, such service was refused on the ground that the brief has been taken from the said learned advocate. So accordingly, the appellant shall serve.
But we are already served. And they have refused. I have a affidavit of service to that.
Accordingly, comma, copies of the applications were served directly on the respondents. From the affidavit of service filed today and kept on record, comma, it transpires that the respondents refused to accept such service, comma, which tantamounts to good service. Full stop. However, comma, since none appears for the respondents today at the time of call, in order to enable the respondents to contest the matter, as a last chance, comma, the same is adjourned for the day. Come back tomorrow, we'll pass on this.
The bishop come back tomorrow.
Tomorrow, because only because of your resolution, Mr. Arifin, we are not passing in orders.
Item number 33.
In this matter, my lord, I am appealing for the appellant. The application for restoration is also there.
Served copies?
Copies served, my lord, every service is there. But today, my lord, whether.
Take on record the affidavit, sir. Affidavit of service filed to be kept on record. None appears for the respondents. In order to enable the respondents to appear and contest the matter, let the same stand adjourned for the day.
Yes.
Next.
Wait a minute.
Item number 34.
Not true. Na thagla di not.
Item number 35 to 42.
Yes, ma'am. Last question,
You're for the other side.
For the referring claimant.
Pardon?
Referring claimants. I'm for the referring claimants.
You're for the referring claimants. State is not there.
My lord, here is some.
This is what? A tribunal application?
It has been converted. Read petition has been converted to the first appeal. Therefore, we required to file the memorandum of appeal. That's why.
Last officer, my lord.
Yes. So have you filed that?
Yes. In earlier occasion, I have filed, but this 8 group batch, we have not yet filed that for formal order is.
Very well. Since the writ petitions have been converted to first appeals, comma, the appellant in each of the matters shall file formal memoranda of appeal within, how soon can it?
Within 3 weeks.
Within 3 weeks from date. Full stop. Next para. Liberty to the parties to mention the matter as and when such memorandum is filed. Matters.
And only one thing, without certified copy, because
leave is granted to the appellants to file such memorandum of appeal without the certified copies of the impugned orders in view of the said certified copies having already been filed along with the writ petitions.
Yes.
রিট পিটিশনের রেকর্ড গুলো কিন্তু আসবে একসঙ্গে, অ্যাপিল গুলো মেমোরান্ডাম ফাইল করবেন কিন্তু এই রেকর্ড গুলো থাকবে।
My lord, I am for the appellant opposite party. My lord, I was enjoying the custody of the minor child, but
You have a resolution, let them come back tomorrow.
yes,
Take it up
take
tomorrow. If they don't appear tomorrow, we'll hear it.
Well, our only matter is that without any order of the court, my lord, child is now in the custody of the mother.
You are for the father.
I am for the father.
Yes, what can we do? Don't take resolutions, we'll hear out matters.
Tomorrow I will come back.
Same, not today. Both side na থাকলে
My lord, in item 44.
What are you trying to do? What are you trying to do?
First,
You are for whom?
we are for the appellant, my lord.
This is appearing for the first time.
The application.
Application in this application for the first time.
দেখি ফাইলটা। When it was dismissed, this is a restoration application.
No, my lord.
We'll take it up tomorrow because there's a resolution. Not good. Same. Both sides nothing.
46.
Unless both sides are there, we won't take up. This is appearing for the first time.
No, my lord, there are the directions.
Then
for
let
filing
us wait for.
affidavit assets.
We'll wait till tomorrow.
My lord. Not today, your lord.
Not today.
47, I am for the respondent. Last occasion, there was a direction for filing a supplementary affidavit.
Very well. Supplementary affidavit filed by the respondent be kept on record.
It has been served. Affidavit is served.
Affidavit of service is there.
Yes.
Along with the affidavit of service of the same. Full stop next para, let the matter, since none appears for the appellant, let the matter stand adjourned for the day.
For the respondent, my lord.
Okay. No appearance today. Yes. Same, no. এগুলো এমনিতেই লোকে রেডি থাকে। Nothing doing. Let the appellant come. Or at any matter where both parties are present.
45 item number restoration.
45?
Restoration.
Restoration other side has appearing for the first time. 45 has already been called on long back.
The other side man refused.
45 you did not appear, it has been called long back. We are now calling 58. Yes. দেখে নিন ওদের দেখে নিন বোথ সাইড না থাকলে নেবো না পুরো ডেকে লিস্ট দেখে পুরো পাগল হয়ে যেত কতগুলো আছে লিস্টে ফোন করুন।
My lord, 188 is an ex parte matter. Ex parte since trial court.
188, what is the matter?
My lord, it's a second appeal from a suit for specific performance. Short matter, one page.
Second appeal, it's a first appeal.
It's a first appeal, pardon me. It's a first.
No, first appeal, if you dispose of without the respondent, then.
But the respondents have never been appearing, not even in the trial court.
If they choose to appear for the first time here, how do you know?
They have not appeared so far.
No, don't do. Not like this. Today at least, no.
Much okay.